This is your lordship, my lord, for granting me leave for a Jalpaiguri matter, my lord.
This matter.
My lord.
So
Tomorrow it will take 2 minutes, my lord. 2 to 3 minutes.
I understand, but the issue is that I cannot take up the Jalpaiguri matters.
No, my lord, there is
Since
no bench.
Monday there will be a bench.
Maybe, but my lord, today there is no bench. At least today I can seek leave. This vacancy
In the two matters,
only one matter.
in two matters, earlier two matters, I have to transpose the records to the Jalpaiguri due to objections that the Jalpaiguri matter should be heard before the Jalpaiguri.
When the bench is there, my lord, sometimes what happens that we wrongly file this matter before the
Yes.
actual. But this is not the same thing. Had there been bench, I could not have filed it here. But now since bench is not there, my lord, that's why I am paying.
Now, why you want to leave? What is the urgency?
My lord, it is a vacancy matter. License will be issued anytime. That's why, my lord. I mentioned this matter before Justice Sen on Monday. He told that you mentioned your witness before a lordship. That's why, my lord. Otherwise, I would have mentioned it.
Very
My lord,
well. Granted.
my lord, mentioning an assigned matter, my lord. There is one
Move tomorrow.
small submission I will make, my lord. The matter is fixed before the court below on 18th, my lord.
What is the matter?
Not the matter is a civil division, my lord, assigned matter.
Assigned matter.
Yes, my lord.
Assigned matter. So, whether it is listed, not.
Not listed, my lord.
Okay. Call the list.
Lord, I appear for the KMDA.
I appear for the petitioners, Your Worship.
I appear for the Kolkata Municipal Court.
On the previous occasion, Mr. Shobhanath Mukherjee had concluded
Yes.
submissions. Yes, Your Worship.
Mr. Mukherjee online.
Last product. Up proceed. It is. Rejected. Approved.
Yes, Mr. Tarapati, proceed.
Yes. My lord, this is the fourth writ petition filed by the petitioner on the same same cause. Here the facts are necessary, my lord, that challenging which the petitioner has come up before this honorable court.
Yes.
My lord, on the last occasion, I tried to raise the point of maintainability, and my lord was of the view that without considering the merit, the maintainability.
Yes, as we have
Yes.
trying to conclude the matter effectively. That's why I want to hear the matter on merit.
Merit.
Yes.
My lord, here I will, my lord, argue on, my lord, of course, my lord, I will have to refer to the certain facts. I will confine my submissions, my lord, primarily on the point of maintainability. And
Yes.
there, the writ petition is a premature one, having no cause of action. And thirdly, my lord, there has been a misjoinder of cause of action, whether this court will consider, can entertain this writ petition in group 1. My lord, first of all, my lord, my 2 points can be answered, my lord. So for the question of cause of action and premature, including the point of maintainability, if your lordship kindly considers.
Saying this is the writ is premature one?
Yes, I'll come. Perhaps, my lord, with due respect to my learned senior friend,
Yes.
my lord, what he has argued on the last occasion, perhaps that is not the case made out in the writ petition. With due respect to him, my lord. And the writ petition, I'll be placing, my lord.
The
First
challenge
of
the
all,
demand of development fee. Only that this is only simplicity the argument is that.
whether at this stage that question, having regard to the past, the facts, the orders particularly passed in the earlier writ petition, whether this court will consider that submission or not. My lord, here, my lord, may I place the facts?
Yes.
That is necessary, and my lord also desired that the facts to be placed. Here the question, only question involved in this, raised by the petitioner, the leviability of development charges
Yes.
by the KMC on behalf of the KMDA, whether that can be. Initially, when the first writ petition was filed by the petitioner, their contention was regarding the leviability of this tax. First, may I refer to that order? I shall come later on, my lord, the other points. In my respectful submission, my lord, this court may not go into all these facts.
In the first writ petition, the petitioner approached this court on which grounds? What was the challenge there?
Yes. That order, my lord, may I refer to?
Yes, it will be better.
Page 100.
100
Yes.
of the writ petition.
Writ petition. The first writ petition moved by the petition. Page 100. Lordship will find this is the initial order, not the final order. On 5th February, the writ petition was moved. When KMDA didn't appear, if your lordship turns to the page, last 2 lines of the order at 102. I am not troubling your lordship reading the entire order, because here the facts remain, my lord. The KMC, if your lordship turns to at page 97, in response pursuant to the demand raised by the KMC, they furnished a bank guarantee, which the KMC wanted to invoke. So,
KMC wanted to invoke the bank guarantee
at page 97.
submitted by the petitioner, and this is the reason they appear before this court in the writ petition.
In the writ petition. So, questioning the invocation of bank guarantee, the petitioner for the first time came up before this court. And initially this order was passed. Page 101, the facts narrated. And the last paragraph starts with the invocation.
Furnish the bank guarantee
Yes.
as per 97.
Page, demand KMC's demand was
Provided however,
As-
okay,
91.
90.
91.
Letter.
In response to the demand raised at page 91 by KMC on behalf of the KMD. It would be better, Millard, if your lordship kindly sees page 91.
Yes.
And-
KMDA development charges,
Yes, and they
3 crore 19 lakh 77,000.
they secured this amount by furnishing a bank guarantee at page 92.
Very good.
My lord, got it?
Yes.
After securing this by furnishing bank guarantee, my lord, they proceeded with the the sanction of the building plan and construction and all this. And thereafter, this bank guarantee, after furnishing this bank guarantee, the KMC sought to invoke the said bank guarantee. When they being agreed by that action, this writ petition was filed.
Very good.
Millard, if your lordship kindly comes to the page 101, here, second paragraph, may I read?
Yes.
The submission of the KMC. Mr. Ghosh, Millard, I will draw attention to those facts, Millard, and documents,
Yes, yes,
Millard.
you proceed.
Mr. Ghosh, the learned advocate appears on behalf of the corporation and submits. It is for the KMDA to say whether the issue has been decided by it. Meanwhile, condition precedent for sanction of plan was payment of this development fee. The plan stood sanctioned. The development made and completion certificate obtained. This is reason for invocation of bank guarantee. There should be no interference. Mr. Abhishek Banerjee, learned advocate, appears on behalf of the bank and submits as of this moment, the invocation is being processed, payment has not been made. The invocation later dated 16 January 2020 does not speak of a demand made by KMDA for the sum of the guarantor. After having it held, it is payable by the guarantor. Court has not been able to obtain the information from the learned counsel on behalf of KMC, the beneficiary. As such, respondent bank will suspend its proceeding on the invocation and pay out till 17th February 2020. The petition will serve a copy of this order on KMDA and file affidavit of service on adjourned date. KMDA is at liberty to mention upon notice to demonstrate that the issue stands decided. So the notice was given to me, the KMDA, and on the later date, my lord, I appeared. Lordship, kindly turn to page 103. This is 10th February 2020 order.
Order dated 10th February.
My lord, this is very important, my lord. Kindly note this date and this order, whether the parties can deviate from this order. The court, Miller, may I read this? Miller, I will trouble you, lordship, this is a small order. This writ petition was moved on 5th February. This is the earlier order I just now read. Interim order was made regarding invocation of the bank guarantee by the Kolkata Municipal Corporation on invocation later dated 16 January 2020 to realize development charges of Kolkata Metropolitan Development Authority. Mr. Talukdar, learned advocate, appears on behalf of KMDA and submits. His client is yet to decide whether development charges are to be paid by the petitioner. My lord, kindly, I am emphasizing on this submission made. Next, lordship, then turn to the next page. The interim order is confirmed. KMDA on deciding whether petitioner is liable to pay development charges to it, and in the event decision is in affirmative, the same is to be communicated to the petitioner and the corporation. Thereupon, corporation will be at liberty to once again invoke the bank guarantee and the invocation later dated 16th January 2020 is set aside and quashed. It is made clear that where KMDA is deliberating on whether development charges are to be imposed on petitioner, right of representation and or hearing to be given to the petitioner. So, my lord, by this order, the KMDA was directed to take a decision as to whether development charges to be paid by the petitioner or not.
No, in the February 2020,
Yes.
the KMDA has not decided whether the development charge will be levied or not.
So that was in
That
the
is the
process.
decision, that is the situation before the coordinate bench.
Coordinate.
So coordinate bench said, you
So you-
take
you-
the decision
You
first,
take a decision.
thereafter it will be considered.
And the Honorable Court also directed that while deciding the issue, the petitioner should be given an opportunity of hearing. So that was the direction. The KMDA is to take a decision.
Yes.
Since we are on the decision-making process. My lord, accordingly, at 105, notice was issued to the petitioner giving, in order to give them opportunity of hearing. At page 105.
Yes.
So as to comply with the order
Hmm.
passed by the Honorable Court. There we have referred to the 10th February order.
Yes.
This order, 10th February order, neither party appealed against. That stands reached finality. Parties are to bound by that order. My lord, in compliance of that order, my lord, we issued notice of hearing to the petitioner, requesting them to attend. And they attended the hearing. And then, my lord, attending the hearing, they have also, my lord, made written submission. There they allege that the legal and factual basis of such claim by KMDA was not disclosed to them. Immediately thereafter, my lord, if you lordship at 101, 109, and the petitioner came up before this court within another writ petition. That factual and legal basis has not been disclosed. We have requested. They only attended that date. They made oral submission and they put it in writing also that they want that explanation. Before that explanation was furnished to them, without providing that much of time, they came up before this court within another writ petition, which was disposed of, my lord, on 13 November 2020 at page 109. So this order is also in compliance of that 10th February order. May I read this order?
Yes.
Since no affidavit has been called for, it is deemed that allegations made in the writ petitions are denied by the respondents. The grievance of the petitioner is that despite a specific order of this court directing the KMDA to decide as to whether any development charge as per demand notice annexed at page 40 of the instant writ petition, that is that 16 November the KMC's demand, is to be paid by the petitioner, the KMDA is not clarifying the basis of such claim to enable the petitioner to respond thereto comprehensively. That was the grievance in that writ petition.
Yes.
It is clear from the order dated 10th February, amongst other orders, that a coordinate bench of these courts specifically made it clear that the KMDA, while deliberating on whether development charges are to be imposed on the petitioner, shall give a right of representation or hearing to the present petitioner. However, although it is submitted on behalf of the KMDA that the hearing has already commenced, it is not claimed that the petitioner's specific queries as regards the substance of the hearing and of the disputes to be decided, as clarified at page 62 of the instant writ petition, have not been answered as yet. It is rather obvious that unless KMDA discloses the basis of its claim for development charges and calculation of the quantum, if any, of such charges, it would not be possible for the petitioner to convert such claim for having a meaningful hearing prior to a decision being arrived by the KMDA pursuant to the previous order of the coordinate bench as indicated above. The submission made on behalf of the KMDA as regards the proposition that disclosure of the answer to the said question as put by the petitioner shall amount to deciding the issue, leaving nothing to be decided further by the KMDA. That was our submission, does not hold water. The issue at hand has to be on the basis of the specific claim made by the KMDA only after affording an opportunity of rebuttal or the name to the present petitioners. In such view of the matter, the WPA 8107 of 2020 is disposed of by directing the KMDA to immediately disclose to the petitioner as to what are the factual and legal basis for imposition of such development charges, which are in question, the basis of calculation of the quantum of such charges, if leviable, and the legal basis of such claim for development charges. Such disclosure shall be made in writing on behalf of the KMDA and communicated to the petitioner within a week. The KMDA will fix further date or dates for hearing within 10 days from such communication on the question whether development charges are to be imposed on the petitioner as directed by the order 10th February in WP number so and so. So, my lord, in continuation of 10th February order,
Yes.
in the second writ petition, the Honorable Court directed us to disclose the legal and factual basis of such my lord, charges and to hear the matter by fixing date or further dates. So this is in other way, my lord, affirming the order passed in the earlier writ petition on 10th February. Am I clear, my lord?
I understand.
My lord, in pursuance of the order, the KMDA disclosed the factual basis, legal and factual, as directed by the Honorable Court.
Factual and legal basis.
Yes, at page 112.
Yes.
There, in the earlier order, my lord, KMDA, that is 3rd November order, the Honorable Court permitted the KMDA to hear this matter upon disclosure of the legal and factual basis to go on deciding the issue. My lord, accordingly, in compliance thereof, my lord, at page 112, we have disclosed the legal and factual basis communicated to the petitioner by our letter dated 5th November 2020.
Yes.
After disclosure of this, if your lordship sees, at page 115, lordship kindly, the last paragraph, the last portion.
Yes. Proceed.
After disclosure of, because in the second writ petition we were directed to hear the issue upon fixing date. Accordingly, my lord, after disclosure of the legal and factual basis, we have fix a date. Lordship, kindly may I read this last portion. It is also being conveyed to you that the next date of hearing as per direction of the Honorable Court passed in 89, that is the first petition, so and so at and fixed at 23rd November 2020 at so and so in the chamber of so and so. The petitioner felt aggrieved by this. I do not know how. And filed another writ petition, being the third writ petition.
Yes.
Third writ petition has been annexed in this writ petition. If your lordship sees without the prayer made in the, it starts from 116. It is very interesting, my lord. If your lordship sees the prayer, the third writ petition starts from page 116.
Yes.
They have annexed the writ petition. Lordship, kindly come to the prayer portion at page 152. 152. What they have prayed for. In all the prayer, A, B, C, I will refer to this.
Yes.
Whether the petitioner was at all entitled to this, having regard to the two orders passed in earlier two writ petitions. The third writ petitions, the prayer made, withdraw, cancel, rescind, my lord got it at page 152. Prayer A, as contained in the notice dated 24th October 2016, that is the KMC's demand. That is the KMC's demand against which bank guarantee furnished. The first writ petition moved.
Yes, you proceed.
First writ petition moved. Court given us liberty to take a decision. In the second writ petition, also we were permitted to take a decision, but disclosing the factual and legal basis. And we are in the process of deciding the issue. Whereas the third petition does not, my lord, lordship will find the a prayer A, my lord, has 24th October. Lordship sees the prayer B, 24th October. Prayer C, 24th October. Prayer D, 24th October. Ignoring the two orders passed by the Honorable Court in their two writ petitions, the third writ petition was moved. My lord, in that writ petition, affidavits were directed to be filed. We have filed our affidavit.
October 24, 2016 is the demand.
Is the demand, is the KMC, page 91. Lordship, kindly turn to page 91. If I am not wrong, my lord, my lord. October, Lordship, at the top right hand side, issue date. This is the issue, core issue. So despite there has been order passed in their writ petitions, ignoring that the KMD is in process of deciding the issue, they filed the third writ petition with the prayer for setting aside of that demand. And none of these two orders was appealed against by the petitioner.
Yes.
My lord, in the third writ petition, the order passed at Lordship, these orders are also material. From 156, the initial order was passed. It is not material. If you Lordship kindly turn to page 158.
Yes.
This is order dated 5th February 2021, passed in the third writ petition. Although, my lord, having regard to these earlier two orders, there was no scope for the petitioner to challenge the original demand. There was absolutely no scope in view of that 10th February order and 3rd November order, passed in earlier two writ petition. Despite that, ignoring that, it is not that they were agreed by the disclosure of factual basis, they have challenged, questioned in the third writ petition. It's not that. They have challenged the original demand.
In the first writ petition, they challenged the invocation of bank guarantee.
Invocation of guarantee.
Invocation of bank guarantee means the demand, on the
raised,
basis of the demand, they furnish the bank guarantee.
bank guarantee.
And you wanted to invoke the bank guarantee after sanctioning
No,
the
KMC wanted to invoke the bank
KMC
guarantee.
invoke the bank guarantee.
KMC
Said they challenged this
challenge
in the first writ petition.
first writ petition.
In the second writ petition,
In the first writ petition, KMDA was invited to join.
yes,
KMDA participated in the proceeding and submitted that we have not decided as yet.
yes,
So the Honorable Court directed the KMDA, you take a
Decided.
decision. While we were taking a decision in the process, they came up with the second writ petition that they are not disclosing the basis. How can we effectively controvert that?
I understand.
Then the Honorable Court directed us to, you disclose the basis. Then we disclose the basis and they fix a date for hearing in order to comply with the order, take a decision in compliance of the Honorable Court's order. Then they came up with the third writ petition,
Challenging the original.
challenging the original.
Yes.
Although that was not permitted in the earlier two writ petitions. So in this writ petition, my lord, this I refer to page 158.
Yes.
This is of course the second order. The first order not so material. Here, my lord, should I place this order?
Yes.
Yes. The petitioner number 1 is the owner of the hotel name known as JW Marriott, situated on JBS Haddon Avenue, popularly known as the EM Bypass. The hotel has 2 towers. The petitioner paid the lease rent approximately 190 crores to KMDA for the land in question, being leased to the petitioner company. Approximately 12.5 crore was paid for getting the building plan sanction. Subsequently, the petitioner required slight modification in the building plan. They applied to the KMC, Kolkata Municipal Corporation. The corporation raised a demand notice dated 24th October 2016 on the petitioner. This is the demand on the company, wherein it was stated that the KMDA that the demand was made on account of KMDA development charges for the sum of rupees 3.19 crore approximately. In this demand notice, that is primarily under challenge in the writ petition, I am told that this demand of KMDA has been secured by the petitioner company by furnishing bank guarantee. I have heard Mr. Mitro, learned senior advocate representing petitioner, Mr. Talukdar, learned advocate representing the KMDA, and also Mr. Ghosh representing the KMC. The issue as to whether KMDA's demand approximately 3.9 crore on account of development charge is tenable requires to be decided by the court. However, this writ petition cannot be decided without exchange of affidavit. Let affidavit in opposition be filed within 3 weeks from the date, as prayed for, reply thereto, if any, be filed within a week. List the matter 4 weeks hence under the so and so. As an interim measure, the demand notice will not be given effect to without leave of the court I am further told that the senior law officer of KMDA is in session of a hearing to decide the justifiability of development charge demanded by KMDA. In terms of the notice dated 24th October 2016, Mr. Talukdar says the said hearing is taking place pursuant to an earlier order of this court in a previous writ petition. Mr. Mitra says there is no such order. In the event, the senior law officer of KMDA does not have the authority to conduct such hearing. So this, my lord, there is no order that cannot be said below. There are two orders on their writ petition. They also question the authority of the senior law officer to decide that. But they did not dispute that the KMDA was directed to decide. Here the point raised that the senior law officer of KMDA cannot decide. He has no authority. But the KMDA is in session of deciding that. Be that as it may, since the same issue is now before this court, it will be appropriate if the proceeding before the senior law officer remains stayed until further order. So the proceeding before the senior law officer was stayed by this order until further order. At this instant, the point of maintainability on being raised by me, that was kept open. Accordingly, my lord, we have filed our affidavit in opposition. You will find at page 64 that we have filed our affidavit in opposition to the said writ petition. And specifically questioning the maintainability of the writ petition also.
Yes.
If you lordship kindly one paragraph from my affidavit, may I show for the time being, at page 167, my lord. It starts from 166, 4A.
This is your affidavit.
My affidavit. 4A, I am referring to that I have raised the point of maintainability, and that was kept open by that order. So in affidavit also, my lord, I have taken that point, that having regard to the two orders passed in earlier two writ petitions, this writ petition, this prayer cannot be entertained. Otherwise, the coordinate bench, the order passed by the coordinate benches, two separate benches, this honorable court has to sit on appeal, because those two orders were not appealed against. So, my lord, if your lordship sees my point, that point I have taken, 4A, the said petition,
Page?
page 166 at the bottom, my lord.
Page 166.
166 at the bottom.
What is your ground for maintainability? 4A.
4A.
Yes.
The petition is totally misconceived, motivated, and frivolous one, having no cause of action at all to invoke the extraordinary jurisdiction of this honorable court under 226 of the Constitution for redressal of the grievances alleged therein. More so, the said petition is completely premature one. No writ, as allegedly prayed for in the said petition, can be issued by the honorable court having regard to the facts and circumstances of the case. Here, my lord, for the time being, pausing here for a moment, my lord has seen the prayers in the third writ petition. They sought for quashing or setting aside of the KMC's original demand, which was already dealt with by the honorable court in the first writ petition as also in the second writ petition.
No, whether that issue was dealt with by this court?
There, KMDA was directed to consider, to take a decision. So pending that decision it is not a fact that the KMDA has decided and that decision they are challenging. No. In the event this prayer is adjudicated, this original demand is decided, then earlier two orders passed in earlier two writ petitions will be negated. The court has to sit on appeal over the orders passed in earlier two writ petitions. Because KMDA was permitted by the Honorable Court to take a decision. Before decision is taken by the KMDA, this court,
বইটা নিয়ে গেছে কিনা
Yes,
sorry,
you proceed.
pending decision by KMDA, this issue, particularly that demand cannot be adjudicated by the court.
So
Because court-
you submitting that in the first writ petition,
Yes.
the challenge was invocation of bank guarantee. In the second writ petition, when the notice of hearing was given, they challenge what is the basis, factual and legal basis of claiming the development charge.
No, here, my lord, may I once again clarify. When the invocation challenged in the first writ petition, then question came that it is on behalf of the KMDA,
No, in the
they
first
raised the
petition,
demand.
KMDA appeared and said, we have not decided yet.
We have not decided as yet whether, because here are documents in this, my lord, records, my lord. The KMDA, the KMC wanted from us to know that whether this is chargeable or not. We have informed them in writing that we will be taking a decision.
Very good. So
That
KMDA
was
appeared
communica-
before the court.
That was
First
communicated
instance
at the first
and
instance.
submits that we have not taken any decision yet.
As yet, then honorable court directed us to
You
take
take
a
a
decision.
decision. You take a decision.
And while taking decision, you give hearing to the petitioner also.
Yes.
What we were doing. In the process of doing, my lord, on a date fixed by us for hearing, they attended the hearing. And in writing, they wanted to know
What is the legal and factual basis?
factual basis. In the second writ petition, their grievance was that though we have wanted to know the basis, they have not supplied us.
Yes.
Not in the second writ
So, Tarun,
petition.
it is very clear. I understand. You have not taken a decision. But
Okay.
that document,
Yes.
that is document impugned, document dated 24/10/2016 is steering. It has not revoked.
It is not revoked. It was,
It is steering.
it-
So petitioner has liberty to challenge that.
my lord, there I join the issue, my lord.
Yes.
If that is decided, then earlier two orders passed by the honorable court, two judicial orders, they are to be ignored.
No, why? They are on separate issues altogether.
No, not separate issue on the leviability of
Okay.
charges.
No, okay, I understand. One demand was made by the KMC
Yes.
upon the petitioner. Petitioner furnished bank guarantee and KMC intend to invoke the bank guarantee.
Invoke the guarantee.
They challenge in the writ petition.
Yes.
You appear and say that no, we have not taken any decision on that point
As yet.
as yet.
As yet.
So
We'll be deciding that.
what that means? The bank guarantee on the basis of the document, is pending without taking your decision.
Yes.
Without taking your decision, KMC has issued the document. So the document was never under challenge before the court. Document dated 24th October 2016 was never challenged before this court. Whether it was challenged in earlier writ petitions? No,
Earlier writ petition is not before.
not under challenge.
No, there the question was the same.
No, I understand question was same, issue was same, but it requires your decision.
My lord,
As you have said before the court that we have not yet
my lord,
taken the
here taking the third petition as on day. In the first writ petition, a judicial order has been passed.
Yes. Judicial order has been passed, KMC to take a decision after giving hearing.
KMDA to take a decision.
KMDA to take decision whether the matter is leviable or not.
That order was not upset by higher court. That stands.
You proceeded to hear,
We proceeded.
serve the notice,
We served the notice. They attended hearing.
they attended hearing. And wanted to know that
and in the process of hearing, my lord, they raised the issues for supplying the legal and
factual
actual
and legal
basis.
basis for levying the
charges.
charges.
We have supplied
Yes.
and fixed another date for hearing,
Yes.
so as to give them opportunity to effectively controvert that, to defend their stand. In that process, they came up with this third writ petition
To challenge the entire demand.
and challenging the entire. So that there was no meaning of passing their earlier two orders. If suppose subject to correction by my lords, what has fallen from in law, I
understand your
follow.
submission. Now I understand your submission. When the authority was given liberty to take a decision on a particular point, such decision has to be taken first.
Taken first.
Thereafter, if they agree, they can proceed this court. This is your submission regarding
Yes.
premature of the writ petition.
So there was, why I have said so premature, there was at that point of time, there was, my lord, no issue before, no such issue. There cannot be any such issue, because under the orders of the court, the process was on. The authority has permitted by court's order.
I understand.
So
Yes.
pending that decision, can you challenge? Can you go back and challenge a document which is to be decided by the KMDA?
So what happened in the third writ petition?
In the third writ petition, my lord, here lordship will find that here also in the third writ petition at page 158, I referred to the order. There also, for the time being, since the writ petition has been filed, that request to be decided on affidavits.
Okay. So
And-
interim order was there.
And the senior law officer who was deciding the issue, he was directed, the proceeding was stayed until further order at
Yes.
page 160.
Yes.
Keeping the maintainability of that writ petition open, my lord has seen.
Yes.
So I have, on my submission, my lord, that point was kept open. Affidavits were directed to be exchanged. Accordingly, my lord, we have filed our affidavit at page 164.
Yes.
I am not going to other points, my lord, for the time being. My lord, we have filed our opposition. They filed reply to that. Oh, I cannot remember. I think they have not done. Reply file করেছিলেন ওটাতে? করেছিল? Yes. My lord, pending this, my lord, writ petition, they have come up with the fourth writ petition, this writ petition,
It is pending. It was not disposed of.
not disposed of.
Third writ petition.
Third writ petition was pending. It a fourth. Third writ petition was pending.
Yes.
Affidavits were exchanged. Matter was ready for hearing. Pending that, although there was no any further cause of action, they filed the fourth writ petition. What is the prayer in the writ petition? My lord has seen the
Instant writ petition.
instant writ petition. My lord has seen the prayers in the third writ petition. Now lordship kindly come to this writ petition. Prayers, my lord, 43 onwards, page 43 onwards.
কথা বলছি বাইরে গেছে মিউট করে দেন ফোনে কথা মিউট
Decide করো। So in a way, what they are trying to challenge, lordship kindly consider this. So many prayers made, and I have also taken the misjoinder of prayers. Lordship will find, though prayer A, B relates to group 1, C relates to group 5, D relates to group 1, again E relates to group 5.
A is for declaration.
Declaration.
not liable to pay any development fee or development charges to the KMDA.
Anyway, the same thing is
The
challenge
provisions of
in other way of challenge. Kindly come to the prayer D. The same prayer as made in the third writ petition.
refund of purported surcharge.
Yes. F also same 24th October demand challenge. H 24th October 16 challenge. While this writ petition came up for hearing, my lord, I took the maintainability of this.
Yes.
And it was the contention of the petitioners that they can maintain both the writ petitions too. My lord, I challenge that.
Yes.
We question that both cannot run. If third writ petition they want to proceed with the third, then fourth has to be withdrawn. If they want to proceed with the fourth, then third has to be withdrawn. My lord, ultimately, my lord, the third writ petition was withdrawn. At page 120, lordship, kindly seize the order. Oh, yes, sorry. এই পেজটা একটু বলো না, তো পেজটা উইথড্র করেছে। এই যে পেজটা কত, ওরা যে উইথড্র করেছে 7 নোটিসটা। মানে I'm give me a moment, I'm showing the order. Withdrawing the writ petition third. This is, yes, it is not denied by them that there is no question also. Even then, my lord, I wanted to show the order. Paste dekhini 120, 220. My lord, I will show that order. The third writ petition was ultimately withdrawn. They agreed. Yes. My lord, take this. I'll show the order. ওই withdrawal order টা তোমার মনে আছে? একটু দাও না আমার। না 9650 টা যে উইথড্র হয়েছে, ওইটা কত পাচ্ছি? পেজটা একটু বলবে? ওই পেজটা একটু বলবে। This is an admitted fact, my lord.
Very well. You proceed.
And the interim order, which was, my lord, passed in the third writ petition, the Honorable Court on the submission made by my learned senior friend, Mr. Mukherjee, that interim order was imposed in fourth writ petition.
Very good. It is continuing.
Yes, here also maintainability point was kept.
Yes.
That I can show from the order. If your lordship sees the order dated, yes, 9th February 2021 order. If your lordship sees from file, my lord, that is not annex.
In this file.
In this file. Order sheets.
Order dated?
Order dated 9th February. That is why I was wrongly searching in the file. 9th February 2022. ওটা petition পাবে না, আমি তো বল করছি। No, no. Yes, yes. No, no, order touch it. My lord got it 9th February 2022. In the order sheets, my lord. If your lordship doesn't get right now, my lord, my copy, kindly have a look. My
Okay. Then
9650 is the third one, third read petition, which is with waiting. না 9-2 এটা কি দেখছো ভুল করছো
এই তো
as recorded না এটা ও না না এটা ভুল করে এসেছিল যে এটা অলরেডি ডিসপোজড অফ এর জন্য যে এটা এই অর্ডারটা পাস হয়েছে
yes.
So my lord has seen the third writ petition was withdrawn
Yes.
because with the similar period simultaneously two writ petitions cannot be maintained. 9th February. And for the fourth writ petition also, the maintainability point was kept open. As I raised in the third writ petition.
Yes.
And in this writ petition also, there was affidavits were directed to be exchanged. We have parties have exchanged affidavits. Now the matter has come. My lord, my humble submission is that why I am submitting that this is premature. The having regard to the earlier two orders, that is 10th February order and 3rd November order passed in two separate writ petitions.
Yes.
The Honorable Court specifically directed the KMDA to decide, to take a decision on the issue. Because before coming to the court, they had already furnished bank guarantee securing the demand. Court has taken note of that. And the KMC was prevented from invoking without the leave of the court until KMDA decides that. In such a situation, my lord, should the KMDA not be allowed to take a decision? My lord, I am putting question to myself. If I do not, I will be held for contempt for violation of the order. And while I am going to comply with the order, they have come up with this writ petition to challenge the parent demand, which was directed to be considered by the Honorable Court, in a way frustrating the process which has been initiated in terms of the order passed by the Honorable Court. And thereby, this, my lord, subject to correction by your lordship, if the prayer of this petitioner is considered, then this court has to sit on appeal over the order passed by coordinate bench, which is not permissible. So when the KMDA has not taken any decision as yet, there can be no cause of action for no fresh cause of action for the petitioner to come up before this court and ventilate. Thereby, I say, my lord, I submit that there is no cause of action for filing this writ petition. Not only premature, because the KMDA has not been allowed to take decision one after another. They are coming up with a writ petition. But earlier two orders, they have not challenged that. None of the parties. The parties are bound by that. So, my lord, this in either way, this writ petition, now third has gone. Now we are on fourth writ petition with the similar contention. And initially, the respondents were permitted to take the point of maintainability because it will be unnecessary exercise to be undertaken by the Honorable Court. And this Honorable Court cannot sit on appeal over the two orders passed by in separate two writ petitions.
Yes.
So the writ petition is premature one. No decision is under challenge. The KMD was to take decision. It is not alleged. The KMD was directed to take a decision within a certain time, and the KMD failed to take. For that, of course, for violation of that, remedy would have been otherwise, or they would have come with a fresh writ petition. This is not a fact.
Yes.
So they came to challenge the parent demand, which was directed to be considered by the KMDA in successive orders, two successive orders. So in view of that, my lord, this writ petition is premature. And since the KMDA has not taken a decision, either it may go in their favor also. So what is the cause of action? I am putting question to myself. There has been no cause of action for filing this writ petition. My lord, on the last occasion I submitted, my lord, this may seem to be a technical one, but it is not technical. It goes to the root. The court will be exercising a wrong jurisdiction. Court has to sit on appeal over the order passed by a coordinate bench, which is impermissible. And the third point of technical point, though technical, my lord, both parties may suffer. The prayers which I shown to your lordship, here, prayer C and prayer E, my lord is deciding this issue under group 1. C and E pertains to group 5. So there has been misjoinder of prayers. They also otherwise cannot maintain these prayers. C and E, according to me, my lord, this relates to group 5.
Refund of surcharge.
Yes. KMD doesn't come within group 5.
KMC.
KMC counts. So this is on my lord, it goes to the root.
Yes.
My lord will be deciding the issue when this court has got no jurisdiction. If I am permitted to say so, my lord, in deciding the issues raised by the petitioner, my lord has to sit on appeal, which my lord cannot do. This court cannot do.
Yes.
So, my lord, now, my lord, I come to the merit.
Yes.
So, this is the twofold submission I will be making. On the face of it, so my lord, so would you lordship one humble prayer, my lord, may I make? Since what I have submitted, my lord, it gives the court jurisdiction. Whether these points will be decided first, if we enter into the merits of the case, then this part.
No, Mr. Talukdar, I have passed only order to hear the point of maintainability at the time of hearing of the matter. That's why I started the hearing.
Yes.
You have to apprise this court on the basis of maintainability as well as the merit, so that I can dispose of the entire matter.
So this will be one part.
Yes. This is your first submission. I have allowed you to that the matter can be heard at the time of hearing. Otherwise, it would be futile exercise.
Yes. Then my lord will decide on both.
Yes.
So now I come to the merit.
Yes.
Here, if your lordship kindly take my affidavit in opposition. Well, so far the relevant pages from the writ petition I have already shown. Because why I have submitted so, if this argument succeeds, then the court need not consider the merit at all.
I understand your submission, but
if my submission is accepted,
always taken a view that I have to hear out the entire matter.
Entire matter.
Otherwise,
so if my first fold of submission is accepted,
it is not required to go into the merit of this matter.
Even then, when submission has been made on merit, my lord has
submission has been made on merit by the petitioner. You have to answer.
Yeah, I have to answer.
Yes.
I have to deal with. Initially, up to the third writ petition, it was the contention of the petitioner that there was no LUDCP and development charges is not leviable on them. And it was strenuously argued that there was no LUDCP in respect of the area where the land is situated. Of course, in the fourth writ petition also, they have, my lord, reiterated that and added some points. But what my learned senior friend has argued on the last occasion, this was neither pleaded nor they have argued at any point of time earlier, subject to correction by my learned senior friend. When altogether a new aspect has been apprised before this honorable court, and this is not the grounds made out in the writ petition even. My lord, I'll come to that. If your lordship kindly takes up my
affidavit in opposition.
Affidavit in opposition.
By respondent number?
By respondent number, we are the respondent number 1 and 2.
Calcutta Municipal Corporation 3.
What my learned senior friend
1
has
and 2.
1 and 2. What my learned friend, my learned senior friend has submitted altogether a new and from the bar. Lordship will not find them in the
pleadings.
So I am to satisfy because the question of leviability on the petitioner is in process. My lord, it will be improper for me, my lord, to say that no, petitioner is to pay this, because that I cannot say in view of the order.
Because you have not taken a decision yet.
And the Honorable Court has already directed me to take
I
decision.
understand.
But on the question whether the land is chargeable,
Yes.
because it was the contention there was no LUDCP. So development charge has to be made, my lord, in terms of the provision of the Town and Country Planning Act 1970.
Yes.
There's provision has been made how and when and in respect of which property such charges can be made. So first question I am to face, my lord, I am to answer whether there was any LUDCP and whether the petitioner was aware of that. That question, my lord, I will be answering first, my lord. I require to answer that. If your lordship kindly takes up the advertisement, because in response to my lord, it's a plot of land, my lord, we have allotted the in favor of the petitioner in execution of a project.
Yes.
My lord, we are the development authority. We undertake different development projects. It's industrial, mixed, commercial, industrial, and some other identical purposes. My lord, in terms of that scheme, my lord, for the purpose of allotting plot with a view to that, because infrastructural development is also our obligation. For constructing a 5-star or 7-star hotel, we have made an advertisement. Lordship, kindly come to that. Page 36 of my affidavit. My lord, got my affidavit?
Yes.
This is an advertisement. Lordship will at the middle, Lordship will find the CMDA logo is there, Kolkata Metropolitan Development Authority, setting up of a 5/7-star hotel in Kolkata. My lord, got it?
Yes.
My lord need not take trouble to read the entire my lord thing. Lordship, kindly come to the third paragraph, last 2 lines.
During tenure of the lease,
A lease deed for the land will be executed. My lord, got it? That line. I'll be drawing your lordship's attention to the specific portion only. Otherwise, it will
very proceed.
be endless. A lease deed for the land will be executed with the successful applicant firm. The project must be within the ambit of the applicable LUDCP. My lord, kindly note this. The project must be within the ambit of the applicable LUDCP and ceiling regulation apart from other related acts and rules. So in compliance of the relevant acts and rules, it should come within the applicable LUDCP. LUDCP means land use development and control plan. It's a development and control plan prepared by KMD. It prescribe the uses and the by zoning and prescription, that plan is prepared. That control plan is prepared. In Kolkata, there are 4 LUDCP. And my line senior friend may apprise. This comes
No, what do you mean that it is applicable to LUDCP means?
Applicable LUDCP means the within the ambit of applicable applicable LUDCP. LUDCP prescribes
A specific plan.
the area particular. It's a zoning and prescription
Okay.
that this area for residential. If it is prescribed so in the LUDCP, there cannot be any industrial or otherwise use.
So it specifies the zone and for
Yes.
what purpose it will be used.
For what
That is LUDCP.
LUDCP. So if
Norms, criteria, guidelines also there, how it is used.
How it is.
how
to be
how
used.
it's
So specific plan is there for the.
There, responsibility, how much area to be left out. Case of such type of the building and another type of building. These are the total knowledge issue. Because the land use.
Okay.
in short, Miller, zoning and prescriptions
Okay, I understand.
are given. That is why applicable word is used there. Well, this is the Miller advertisement we have published on 20th February 2006. At the
Yes.
top, you will find the date.
Yes.
So there was Miller. I have given the type copy because it is very difficult to read. And then Miller, this advertisement was Miller corrected or amended. An addendum was published, Lordship, page 39, in connection with that advertisement.
Yes.
There, Lordship will find at the third line. I'm not reading. I'm reading that first paragraph. In view of the large number of queries received by KMD in response to the above advertisement dated 20th February 26, a set of clarification has been prepared by KMDA, giving the details, terms and conditions, eligibility criteria, LUDCP site. So LUDCP, that it should be within the applicable LUDCP, ambit of LUDCP was made known in the advertisement, starting from the advertisement itself. Because
Yes.
we also cannot permit ignoring the provisions of LUDCP. So in response to that, the petitioner applied for.
Yes.
And the petitioner's bid was, petitioner succeeded. Petitioner succeeded and it was allotted a plot of land for constructing a 5-star hotel therein. For a lease deed was followed. If you, Lordship, kindly come to the lease deed executed. For the lease deed, my Lordship, kindly take trouble to take the writ petition.
Okay.
I have not annexed that lease deed since the petitioner has annexed that. Page 56 of the writ petition. It starts from 55.
Yes.
When a few clauses of the lease deed, they cannot say they were taken to surprise by this development freeze under the Town and Country Planning Act. I shown to your Lordship the advertisement that right from the advertisement, the LUDCP was it was made clear that it should come within the applicable LUDCP. If LUDCP is applicable there, LUDCP says what says, then one has to comply with. Thereafter, lease was executed on 28 September 2007. Few clauses for a cursory glance, are necessary, If your lordship kindly come to clause 2 at page 59. Well, certain clauses, my lord, I will be referring to. This is exactly this is exactly, my lord, what in the addendum I have shown to your lordship.
Page,
My lord, just now, my lord, I have shown to your lordship the addendum to the advertisement at page 39 of my affidavit. That is quoted here also. My lord, next lordship kindly come to 2B. 2B, your lordship will get here the numbering is done in at 62. Numerical number is first it is made up to 12, then again
1, 2.
1, 2.
Very
So lordship kindly come to page 62.
Yes.
62, 2B. Here the plot of land was, my lord, allotted in favor of the petitioner on leasehold basis for 99 years. That is also lordship will get from page 62. 2B, the lessee shall during the term pay all present and future tax, rate, taxes, charges, and other imposition. I am emphasizing on this word, other impositions of every description. My lord, kindly note it. Other descriptions of every description, other impositions of every descriptions in respect of the demised land and the building erected or to be erected there. Then your lordship kindly come to page 2C. That is the next page. See Roman 3.
Yes.
Roman 3, their time has been stipulated, my lord, for making construction. There is no dispute. We are not, my lord, raising any issue on that. But since it is necessary, my lord, just I am showing this clause, my lord. That particular time limit was given for making construction. Here, why I am referring so, lordship kindly come to the last portion of this paragraph. Within 3 months from the date of final sanction of the building plan for setting up a 5-7-star hotel with boundary walls, so and so and so, according to rules and regulation of the KMC, and, my lord, this part, lordship, and according to the requirement of any statute of any land and land use and development control plan and development control regulation of the authority pollution. Here also reference was made to the LUDC. Not only the other acts and rules, the provisions has to be followed while making construction. The LUDCP has also to be followed. That means, in other way, LUDCP will be applicable in this case. Then your lordship kindly turns to D. 2D.
Yes.
The lessee during the subsistence of the lease strictly adhere to and follow prevailing rules regulation as stipulated, including under the provisions of the Kolkata Municipal Act, Kolkata Municipal Corporation Act 1980, Kolkata Municipal Corporation Building Rules, and West Bengal Town and Country Planning Act 1979, under which LUDCP is prepared.
Yes.
So 79, along with other relevant acts, 79 Act was also required to be followed. Then your lordship kindly come to the next clause. this is not not relevant on this issue. So, my lord, in the lease deed also, it is specifically mentioned that the construction has to be made not only within the specified period of time, but in accordance with the relevant acts and rules, including 79 Act and the LUDCP to be followed. So LUDCP, regarding the LUDCP, had it not applied to the land in question, the leasehold interest, leasehold land, reference to the LUDCP would not have been mentioned there.
Yes.
So in respect, it was their contention earlier that in respect of the demised land, there was no LUDCP. So how the KMC can charge development charges? Development charges can be made, can be charged if LUDCP there is any LUDCP, valid LUDCP, then question of charging development charges comes. That was their contention. So LUDCP is applicable to the demised land, the leasehold land. That is why reference was made to the not only the 79 Act, but specifically right from the advertisement, the LUDCP was referred to, even in the lease deed. Now, my lord, it was also their question. The land was demised in 2007. At that point of time, they referred to, my lord, in the writ petition, one notification of 2008. Referring to that 2008, I'll show to your lordship the document they have referred. They wanted to say initially, lastly the argument was altogether changed, that it cannot be, my lord, it cannot have any retrospective effect. It is 2008. Land was allotted to us long before.
Yes.
In 2007, lease deed was executed. So how can you make it applicable to in our case, even if that is made, the LUDCP is there. Then how development charges comes in? My lord, it is our specific case that LUDCP was in existence since a March before. That to show that, my lord, if your lordship kindly come to my paragraph, I will be showing the document also.
Paragraph of your affidavit.
Affidavit, lordship, for a moment.
Yes.
My lord, may I read from paragraph at page 5, paragraph F, this 4F.
Yes.
My lord, few paragraphs, my lord, is necessary for me to make it clear, my lord, to read this. Clause 2D of the lease deed also stipulates that the lessee during the substance, just now I have placed that, referring to the clause D. Yes, G. From the aforementioned provision of the lease deed, as also the condition mentioned in the advertisement, it clearly goes to show that the construction of the hotel on the demised land must not only be in accordance with all those related acts, rules and regulations as referred to above, but also as per the requirement of the land use development control plan and or development control regulation of the authority. It also evident from the records that the petitioner company neither applied for development permission from KMDA, nor the case was initially forwarded by the KMC as per the standard procedure, since the case requires such approval from the KMDA in view of Section 45 of the West Bengal Town and Country Planning and Development Act 1979. Here, my lord, one thing may I say, my lord, within the KMC area, when an application is received for sanction of a building plan, my lord, KMC refers it to the KMDA that seeking observation on that. In order to, my lord, whether that is acquired or not, one aspect, whether development permission is required or not. So in this case, neither the petitioner has sought for any permission, nor the KMC had, before granting sanction, had apprised the KMDA regarding that. That is what, my lord, I wanted to say in this affidavit. If your lordship kindly turns to page 40 of my affidavit,
40.
40. Because why this? Because there is a restriction.
Notifications.
Yes, notification is a notification. If you also kindly takes up the type copy at page 41, because 40 is not so legible.
I understand. Proceed.
It's a notification dated 1997. In exercise of power conferred, notified the general information in exercise of the power conferred upon it under section 134 of the Town and Country Planning Act 1979, the Calcutta Metropolitan Development Authority, by a resolution adopted in its 123rd meeting held on 26 December 1996, has directed the following amendment in the amendment shall be made in the notification dated 85 as amended notification so and so. No permission shall be given for development of any land located within 500 meters on either side of the central line of Barakpur Kolani Expressway, National Highway, and the Eastern Metropolitan Bypass, Belgharia Express, and the streets are mentioned, without first obtaining the concurrence of the Chief Executive Officer, Kolkata Metropolitan Development. So this was the reason, my lord. The whether that comes within that, for that, the KMC, before granting sanction, has to approach the KMD that where the land is located. In the instant case, neither the petitioner nor the KMC, before granting sanction, had apprised that. Then your lordship, another.
Within 500 meters.
Yes.
No construction within 500 meters.
Then, my lord, few paragraphs, my lord, may read. Then next H.
Yes.
Here one more document. Just, yes. It appears that the petitioner company only obtained a building permit, that is sanction of a building plan from the KMC on 24 July 2008, and the matter issue of development permission vis-a-vis the development charges was not initially considered by KMC. Section 134 of the West Bengal Town and Country Planning and Development deals with the power of delegation, wherein it is stated that any planning authority or development authority may, by resolution, direct that any power exercisable by it under this Act, rules or regulation made thereunder, may also be exercised by any local authority or any officer of the state government with the previous consent of the state government or any officer of the planning authority, development authority, or local authority, as the case may be. In such cases, subject to such condition, if any, as may be specified therein. In the instant case, the KMDA did delegate such power to the KMC in July 2014 through a resolution in KMDA board. Therefore, the collection of development charges by KMC as per pre-delegated power apposite is quite legitimate belief. Here, Lordship, I want to show the documents at page 46 in support of that. Lordship will find second paragraph of that page regarding the delegation of power, because the I will show to the show to your Lordship the provision of 79 Act, because 134 of 79 Act deals with the delegation of power by KMDA. Here the authority, the KMDA being a development authority constituted under the 79 Act, may delegate its power, which would have been exercised by it upon any local authority. Here including the KMC. KMC also comes within the local authority. Here the KMDA had delegated the power. And in exercise of that delegated power, the KMC, on behalf of the KMDA, made that demand. Here, my lord, I am showing this page, this memo, my lord, particularly the second paragraph. In the year 1985, Lordship, my lord, got it? At page 46 of my affidavit.
Yes,
I'm reading from my lord, second paragraph.
yes.
In the year 1985, KMDA, in exercise of power conferred upon it under section 134 of the Act, delegated its power under 46 of the Act to different local authorities for receiving the application for permission under section 46. So 46 deals with the development permission within their respective jurisdiction and dispose of the same in accordance with subsection so and so. And the latest amendment, my lord, I skip a few lines, my lord. I come to the last line of that passage. The latest amendment of condition 4 dated 1997 as follows. My lord, this, by way of this memo, my lord, this was 4 was added. Then, my lord, 4 was added.
The amendment.
Amendment. And 47, third line also, my lord, will find. It may be mentioned, I read the 3 lines from that passage. It may be mentioned here that under subsection A of section 45 of the Act, no development can be carried out without payment of development charges.
You are
Charge
reading, it may
and-
mention here that. Third paragraph.
Third paragraph. It may be mentioned.
Okay.
Yeah. My lord, I shall show to your lordship the provisions of 79 Act, because 45 deals with the development charges. And the rate of development charges levied by KMDA duly notified under subsection 1 of 102 so and so dated 26/11/2008, following a notification of another notification referred to. This referring to this 2008 contention, it was the contention of the petitioner that even if that was of 2008 and we were allotted before, so we do not come under this. But facts remain, my lord, it is not development, it existed long before. Then the later part is not so relevant for this case. If your lordship kindly turn to the next page, 48. The first paragraph. It may kindly be appreciated that while KMD is empowered under the Act to levy development charges for the entire Kolkata Municipal Corporation area, it has decided to restrict it only to some arterial roads. The KMC understands generates huge revenue from granting development permission in other areas. In terms of the notification referred to above, 80% of these revenue are to be credited in favor of the KMDA. I would request you to kindly intimate the total amount received on account of such charges, and so it is in between. Then your lordship, Then your lordship kindly turn to page 49. This is written by KMC to KMDA in July 2014. In continuation of a matter was placed so and so and was resolved that the KMC may collect the development charges as envisaged as per provision of section 45A of the West Bengal Town and Country Planning and Development Act at the time of collection of sanction fees. So here at the time of sanction, this development charges was not collected, which they raised later on after granting sanction.
Yes.
And it can also be done. I will show from the KMC, the last line lordship read this, requested to empower the KMC to collect the development charges on behalf of the KMDA. KMC wanted to collect the development charges on behalf of the KMDA. So decision was taken by the KMDA. Yes, because the earlier later I have shown that the KMC was permitted in 2014, the power was delegated. So at page 50, if you lordship kindly sees, it is very difficult to read, my lord. Page 50, there was a deliberation on the issue, and ultimately the KMDA decided to delegate the power of collection of development charges by KMC, and the minister in charge, who is also the chairman of the KMDA, approved that. At the bottom, lordship will find the handwritten note. This is by MIC. And the board had also decided, the KMDA board, in its meeting at page 51. I am on the delegation of power, whether the KMC can collect the charge on behalf of development charges.
On behalf of the KMD.
On behalf of the KMD. So KMC was authorized, the power was delegated.
You are referring page 51.
51 is a resolution of the board, which usually called as authority meeting. The relevant portion lordship will get at page 52. 52 at the middle, 29. My lord got it. Planning matters. The decision. Here the proposal refers to ratification of the proposal of empowering KMC to examine the development proposal in the light of Land Use and Development Control Plan (LUDCP), levy of development charges on behalf of the KMD for sanctioning building plan in plots within 500 meters from either side. Decision. The proposal was ratified by the authority with the decision that 90% of the necessary charges received from the development permission will be remitted in favor of KMDA. KMC will retain 10%.
Yes.
Then your lordship kindly turn to the next page, page 53. The KMC also themselves had resolved by a resolution. This refers to a resolution of the KMC. It was their resolution that the KMC will retain 20%. My lord, at the E, just at the middle, the KMC will retain E.
20%.
Yes, 20%, and residual amount will be transferred to KMD. And then G also says, my lord, here they will collect within a specific time. The KMC will, if the payment, they will demand charges. If payment is not made, they will issue stop-work notice. It is their KMC's resolution.
Yes.
Then lordship kindly come to page 55. This is also part of their KMC's resolution. At the middle, lordship will find sentence starts from under the circumstances.
Yes.
Department proposes so and so. KMC will collect development charges on behalf of the KMDA as per the provision 45A West Bengal Town and Country Planning Act 79 Act along with sanction fee KMC. The KMC will ask KMDA to provide necessary document of approval so and so so and so. So these documents goes to show that in terms of the provision of 134 of the Town and Country Planning Act, where the KMDA is empowered to delegate its power, and in exercise of that power of delegation, the power to collect development charges was delegated to KMC. KMC can lawfully demand development charges on behalf of the KMD.
So entire submission is that KMC's demand is lawful.
Lawful. Because it was questioned that KMC is demanding, KMDA, not the KMDA is demanding. But that power of KMDA, what could have been exercised directly by KMDA under section 134 of the 79 Act, it can also delegate its power to some other local authority, which it did. And in exercise of that delegated power, the KMCA had raised that demand.
Yes.
My learned friend says that on some other day. Now, my lord, I'll come to, my lord, some provisions, my lord, are necessary. Here, না এটা লিঙ্কটা হারিয়ে যাবে একটু লিঙ্কটা হারিয়ে my lord has got that Town and Country Planning Act, perhaps
Yes.
not.
Okay.
My lord, for the time being, kindly have a look 134.
132.
134. Because just now we are on this issue.
Yes.
Plus you will find that the power of delegation is there. Any planning authority or development authority may by resolution direct that any power exercisable by it under this act, rules, regulation made thereunder, may also be exercised by any local authority or any officer of the state government with previous consent of the state government or any officer of the planning authority, development authority or local authority as the case may be. So power is there in the act itself. Now, Lordship, kindly, one more provision is necessary. So many provisions will be necessary to consider. Lordship, kindly take section 106.
Yes.
If any, this is development charge to be charged on land and to be recovered as arrears of land revenue. How it is to be recovered. If any development of land is commenced or carried out or any use is changed without payment of the amount of the development charges, such development charge shall, subject to prior payment of the land revenue, if any, be the first charge upon the land involved and also in any other land in which such person has any interest. Even that can be collected, that will be treated as a
Yes.
it will be the first charge. Now, my lord, I have referred to the provision, but I have not shown to your lordship. If your lordship kindly at the same time, section 45 and 46. Section 45 makes a prohibition that without payment of development charges, there cannot be any development.
Development without payment of development charges.
Yes. And granting provision is under 46. So 45 to be resorted while sanctioning a plan or if someone intends to make construction, my lord, one is to apply for permission. And 45, and development authority grants permission under 46. For the time being, my lord need not go into all these aspects. Now the question comes, my lord, whether now it is clear, my lord, from these documents that KMC was duly authorized to raise their demand. It is not that the KMC had unauthorizedly demanded that amount. It's a demand of the KMDA which was raised.
So till
Now,
today,
let us stop here. Now,
of today.
I will have to come on the core issue, whether the land is chargeable or not.
On the next day.
Next. My lord, I thought that I may not enter into the merit even.
First of August,
1st of August.
10:30.
1st of August.
21st of August.
21st. My lord, just a minute, my lord.
According to lordship, then we need 21st August.
Instead of 21st, any other day, my lord.
21st, you are busy, Mr. Talukdar.
Some other matters are fixed.
21st, 22nd,
22nd.
Friday,
So it will be taken
10:30.
only in that week. If your lordship wants, my lord, in the next week I can do it.
Next week, I cannot accommodate you. I have already fixed several matters.
Then would you lordship kindly the prior week? It can be on 14th also.
No, 15th.
No, 14th, I have other business. 14th, no.
Then, my lord, after 22nd, kindly take off. Somewhere I will have to pray for time. That's the embarrassment.
I understand. No, you have to conclude it.
Yes, I'll conclude. I will not take much.
28th.
28.
Mr. Mukherjee, 28th.
Lordship, the interim order is perhaps expiring on 22nd, if your Lordship will kindly extend.
Friday আটকে আছে আমি 27 শেষ 28 শেষ
Kindly extend the interim order. The interim order will expire.
Okay. 28th of August.
20
Please take down.
at 10:30.
Mr. Shoktinath Mukherjee, learned senior advocate, appears virtually on behalf of the petitioner. Mr. Satyajit Talukdar appears on behalf of KMDA. Mr. Alok Kumar Ghosh, learned advocate, appears on behalf of KMC. Today, Mr. Talukdar argued on the point of maintainability as on point of merit. Full stop. Argument continues. Let the matter appear in the list on 28th of August 2025 at 10:30 as a specially fixed matter. Full stop. Next para. Interim order passed by this court, which was extended time to time. Lastly, till
I think it is till September end.
it was lastly extended. When it was extended lastly?
Last extended.
It was extended time to time. Okay, very well. Which was extended time to time. Be further extended till 19th of September 2025 or until further order, whichever is higher.
Gratefully.
My lord will be hearing the matter as well.
I will dispose of the matter.
Yes, yes, yes.
I will dispose of the matter.
My lord, we are ready to cooperate, my lord.
Okay, okay. It would be better to dispose of the matter on all merits. Otherwise, it would be difficulty. Again, it would be went up
It is
to.
good for us also, but if we get the chance of
Yes, yes.
successively.
Very good. Thank you.
Much.
Thank you, Mr. Mukherjee.
Item is also mine. Can I do it on the next Thursday?
Let me see.
Oh. Well, Lordship will take up the 12:30 matters or because item number 2 is also 10:30 matter.
And 3 is also 10:30. Item number 3, my lord, 10:30.
I'm also there for 12:30.
then my matter, the item number 2 may be taken up.
I have 4 matters, 10:30 matters.
10:30. So 2 may be taken up in the next Thursday.
So, Mr. Talukdar, you are in item number 2.
2.
Who is for the petitioner?
Petitioner.
My case is also there.
Is Mr. Partha Chakraborty. My argument is going on. I have
Your argument is going on.
yes. He has completed. Just I started on the last occasion.
I understand. So, when you can start?
My lord,
Next
my
week?
lord, next Thursday. Next Thursday, can I do it?
Next Thursday?
Thursday 10:30.
No, not 10:30. Next Thursday it will be 12:30,
12:30.
if you want.
That matter also, my lord. I need that.
12:30. 14th.
14. ঠিক আছে তো?
Item number 2. Let the matter appear in the list.
Just before independence.
What?
Huh?
Let the matter appear in the list on 14th of August,
Huh?
2025
14.
at 12:30.
But this matter will not complete because Mr. Talukdar started the submission.
Yes,
Let him complete, Mara. It will take reply within half an hour. The reply will be
let him complete first. Now we were.
He is not completing. That is the whole difficulty, pain.
No, Mr. Talukdar has argued at least 2 hours.
I have seen.
So today he is relieved. But 14th, 12:30.
12:30.
Next Thursday.
Within an hour, I will complete.
Okay.
My lord, the item number 3 is also at 10:30, my lord.
Item number 3.
3, my lord.
This appeal.
My lord, I am for the appellant and senior counsel.
আমাদের চলবে বুঝলে
And who is for 12:30 matter?
I am for the 12:30 matter and my lord
12:30 matter, item number 5. My lord, in this matter, Mr. Siddhartha Chaudhary.
Just wait.
Item
I want to
5.
know who is there. So I will take up the item number 3.
yes
Item
and
number
lordship
3.
so far as 5 is concerned lordship can reschedule it so that we don't have to wait.
No, only 5 or 6 minutes I will hear this matter.
Oh, then we will continue.
Yes.
But then my learned friend
I-
friend is saying that
I
he
am
will take
praying for
adjournment.
time in item number 5. My lord,
As it is, he will be asking
Laner
for
request
tea.
Siddhartha Chaudhary is on his leg before another Siddhartha Banerjee. My lord,
Actually,
kindly make it not today, my lord.
Not to do, what does it mean? 12:30 fixed matter, how can we not to?
My lord, he's on his
It
leg.
has to be fixed. It has to be fixed.
My lord.
Item number 5. An accommodation short for on behalf of the petitioner.
Petitioner, my lord.
Let the matter appear in the list on 29th of August 2025 at 12:30.
God bless you.
Lordship, meantime, what happened? We had prepared our affidavit in opposition, but probably my advocate on record, Sonchita Borman Rai, she is very unwell. She probably has lost it.
So can I reaffirm and give it to your lordship? Can I
Affidavit
file it?
already in exchange, my lord.
That's what I'm saying. Lordship,
ECL
affidavit
filed.
we have prepared and then we have to file it. If your lordship,
No, you
allow
have
me-
placed it already. No, not filed.
Lordship, I am not very sure whether it is in the court's record or not.
ECL already filed, my lord. ECL already filed opposition.
That's what I'm saying.
So
I have already-
I will take up this matter to get it
No,
ready.
no, my lord,
I'll take up
I
this
can,
matter on
I can
29th.
show before your
CBD has filed, the
EC.
state has filed, ECL on the last occasion sought for some time to prepare the opposition.
No, my lord, my lord. It is on record that ECL already filed, my lord.
So you are appearing on behalf of ECL.
Of course.
So you
What
have,
I am saying is
if
either
not filed, if
if-
not on the record,
if it is
It is filed, my lord. Already.
আপনি বলে নিন পরে বলছি।
তাহলে
হ্যাঁ, বলে দিন।
order for filing reply, let them file.
Re-
বলছে ওরা prepare করেন কি বলছেন?
Lordship, kindly extend me 7 days time to reaffirm it.
I
Means,
understand. Let me find out the record first.
so we have to check it in the record. দেখুন তো respondent number
Item
7 এর
number
ইয়ে আছে
five.
কি?
That will be better to check the record. Respondent number 5.
7.
This is the reply, my lord. Yeah, we already filed in respect of
You
the
have
opposition.
filed reply.
Yes, my lord.
Let me find out whether the affidavit is there or not.
না না রেকর্ডে থাকতে পারে কিন্তু তাহলে আমাকে রিএফার্ম করতে হবে আমাদের রেকর্ড থেকে হারিয়ে গেছে।
Affidavit in opposition on behalf of ADDA. Affidavit in reply.
আমরা 7 থেকে 10
I think it was affirmed on 7 September, my lord. 7 September 2021, as it appears from their opposition.
Your senior is correct. You have to reaffirm.
I filed.
Recording. See, it was fixed for hearing. We, lordship on the earlier occasion found out that it's not on record. That's
Not on
why
record.
my
It
learned-
so happened that the advance
Yes,
copy
yes,
or
Okay.
I might have served them but we could not file it. So Lordship kindly allow me.
Respondent number 7.
Yes Lordship. 7 to 10.
7 to 10.
Yes Lordship.
Respondent number 7 to 10. Is that leave to reaffirm the affidavit in opposition?
Instead of reaffirm certain new facts has also come, then I will incorporate those. Because
My lord,
as it is,
No, no,
we
you have
already
already
reply, in reply already filed. It has been
reply.
and it is only affirmed. How can is it
Right.
filed in the new man?
Okay. You know? Reaffirm the affidavit in opposition, which they have already served upon the petitioner,
and they have also filed reply to it.
and over which they have also used the reply.
List.
Let the matter appear in the list. Proceed.
My lord, is there any, if there is any additional amendment or additional document in respect of this affidavit, I have to file the exception.
Yes.
If
that's what I'm-
additionally it is
No, I cannot
yes.
now.
No, Lordship, what I'm saying.
They
already exchanged, if they are
Allow me to
filing.
use
They form it.
allow me to use a supplementary affidavit as well.
And
So that entire picture can come before your Lordship.
And
Because
directed-
for it, we
directed
will not
the,
hide anything.
they
also
directed the
affirm-
learned advocate to serve the again after filing.
খুব মুশকিল বাবা, একটু দাঁড়াও। I will file a supplementary, he will file a exception to it, and then Lordship fix a date. Maybe in September.
এই দাঁড়াও।
তাহলে complete হবে, তাই?
It appears from the record that
কেউ জানে না কোথায় পা দিল।
no affidavit in opposition has been filed on behalf of respondent number 7 to 10. ECL. However, the petitioner has received a copy of affidavit in opposition from respondent number 7 to 10 and used a reply. Learned senior counsel appearing on behalf of the ECL submits that during the course of hearing of this matter, the affidavit in opposition, which was affirmed earlier, had misplaced, so they could not place the same. Next paragraph. Learned counsel for the petitioner seeks liberty to file a fresh affidavit,
my lord. I think
fresh affidavit in opposition against the writ petition. It appears that the matter is ready for hearing at this juncture. There are no pleadings on behalf of ECL on the record to decide the matter. Logically, the ECL should be given an opportunity to use affidavit in opposition afresh. Let the affidavit in opposition be placed on record within 2 weeks. Within 2 weeks, by supplying a copy of the same to the petitioner. Reply, if any, by the petitioner within 1 week thereafter. 2 weeks, 1 week, 3 weeks. 1, 2, 3. 1, 2, 3. Let the matter appear in the list on 4th of September 2025. Under the same heading at 12:30.
my lord.
My lord, in the next matter, my lord, item 6, it is also fixed at 12:30. I can see my learned senior friend there for the petitioner, my lord. My lord, I am in some difficulty today, my lord. If it could stand over for any other day, or let my learned senior friend, my lord, conclude today, I shall give the reply on the air.
It is third time matter was fixed.
But we have not taken any adjournment, my lord. Some other matters had spilled over, so that is why, my lord.
This matter is supposed to hear today.
Yes, it is fixed at 12:30.
12:30.
You just wait. I take up the matter, only one matter at item number 3 for 5 minutes. That will take up your matter.
My lord, I am saying that there is some difficulty today, my lord. If it could stand over till any other day, my lord, next week.
Okay, যখন ডাকবে তখন হবে আবার কি মাঝখান থেকে বলার কি আছে?
Wait, just wait.
Lord, item number 7 is also my lord.
No, just wait. Item number 3, I will start first.
Then your lordship, 6 is fixed on.
I will take up after 3.
এখন তিনটে রাখছে দর্শক 3
I will take up after 3. Yes. What is your submission?
দর্শক
Just wait. Item number 3 I have taken.
Lordship, for your lordship, recapitulation of the memories.
Not necessary recapitulation.
And to afresh to give some outline.
Paper book to dao.
এই পাতলা বইটা হ্যাঁ
পেপার বুকটা কি টাকার কি লাগবে হ্যাঁ দিন নকটা লাগবে না ওটা কোনো ইয়েস
just for 1 minute a suit was filed.
No, I know the fact. You don't have to apprise this court on the facts.
Then I need not to be trouble lordship for placing the factual aspects. I need not to trouble. Only I just remind this matter, my lord, that the plaintiff file a suit for declarations and recovery of khas position and permanent injunction in respect of a place of property, which is the turned down by the trial court. Against that, an appeal was filed by the plaintiff before the appellate court. Appellate court, after hearing the respective parties, perusing the evidentiary documents, thereafter pass an elaborate order in favor of the appellant. Against that, order of the my lord, appeal court, the OP and defendant, they have come up before lordship in a second appeal. Now, second appeal was placed before the division bench of the High Court. Grant interim order certain limit. Thereafter, my lord, framing the 5 question of law. And on the basis of my lord, this 5 question has to be dealt with for proper adjudication of the matter by this court. My lord, this in that
I know that you proceed.
my lord, I subject to kind sanction. I'm submitting before lordship that I'm not wasting my lord, much more 1 or 2 minutes time, lordship. My lord, this is the backdrop. Thereafter, my lord, now I have to deal with the 5 questions which has been formulated by the my lord, division bench, and accordingly I have to restrict my submissions with regard to the only 5 questions. My lord, now I'm dealing with the, so far the first question is concerned.
We have already dealt with the first question, second question, third question,
My lord,
and fourth question. Only 5th question is required.
My lord, just
to be dealt with.
my lord,
Yes, I have heard
I know,
4th time.
I
You
know.
cannot start again.
No,
This
what,
is the issue.
my lord, what I tried
I
to
cannot fix a regular date for entire hearing of this matter.
your lordship desire was, your lordship desire.
Yes, my question is, last time, whether the relationship between the licensor and licensee has been proved. This is the last question. You want to apprise this court on that point.
No, my lord, what I tried to assist your lordship.
You show me whether there is pleadings, what are the proof, and what is the observation of the learned court below, and what is the observation of the learned first appellate.
So far my remembrance is concerned, your lordship, my lord, question falling from your lordship's mind, that the appeal court reversing the judgment of the trial court, reversing the order of the appeal court by the appellate court without having any evidence.
Go to the question number, formulated question number 4. This is there. I have not opened yet anything.
No, but only yes, I'm without opening my brief. Only I'm giving a lordship outline so that your lordship can come to the point. My lord.
That is the last question, whether learned judges of the court below is justified in reversing a judgment and decree of the trial court when relationships of the parties claim to be licensed if not proved by the plaintiff. This is the last question.
Lordship.
This is the last point you are arguing on the last occasion. We stop there.
My lord, your lordship apparently correct. But so far my part is concerned, I try to assist your lordship, corroborating the lower court's orders, finding the appellate authority, as well as my submission, so that your lordship can complete the hearing proceeding. My lord, so far the query which has been formulated by the division bench in respect of this matter is concerned, whether the court below justified in reversing the judgment and decree, the trial court, when the relationship of the parties as claim or licensor or license, if not proved by the plaintiff. But so far the query is concerned, or the question of law which has been formulated in this question number 5 is concerned, I try to assist the lordship, my lord, that the suit which has been filed before the court below, when the father of the appellant herein, Bipin, was in life. He was expired on in the year of 2018, April 1984. Prior to that. Now, the suit Your lordship take trouble to the depositions of the PW1 at page
Sir, I have read entire depositions. I have read entire depositions thrice.
Only I'm just reminding your lordship the relevant portion so that your lordship can, the query which has been following from your lordship, we try to corroborate this portion, not much more, not required to be gone through the entire matter. Because so far your lordship's query is concerned, lordship. Page 10 of the judgment.
Yes.
In continuation to that answer, I am reading your lordship from page 9 so that your lordship can take note of this. In this suit, there is no evidence that at the time of alleged granting of license, possession was delivered by the specific measurement. No evidence is also appeared before the court that the dispute 8 decimal of land as mentioned in schedule Kh to the plain is demarcated and operated from remaining 52 decimal of land. Moreover, the LR record rights shows that since 1365 BS, plot number 477 was not in a position of the original owner, and it is now in possession of the Mrityunjay Haldar. So let Bipin Haldar, son of. There is no dispute that plaintiff is the owner of the disputed property by purchase. From Exhibit 2, my lord, just so far your lordship's query is concerned, I try to just
proceed,
lordship. 2, registered deed number 2149/1943, it appears that the plaintiff purchased the 1.61 decimal of land of disputed Khotians, but there is no evidence that he got possession of the property after purchase. So, from all the aforesaid documents and evidence on record, also this court failed to come to a conclusion that alleged relation of the licensor and license was actually exist between the parties or not. This is the observation of the court below, trial court. Well, what is the suit before the court? The suit for declaration. Suit for declaration, injunction, and recovery of khas possession. So, a party who is approached before the court for seeking a direction for his right title interest of the property. Now, my lord, on the basis of registered deeds, what else could be the correct piece of evidence wherefrom it can be revealed that he is the owner of the property or not? So, upon taking into considerations of the entire aspect of the gamut of the matter, that suit for declaration on the basis of registered deed was declined. Only on the basis of that whether he is a licensee or license or whether he has been executed any valid license or not, whether there is an existence of license or not, on the score, the entire suit for declaration was gone. Against that, the appellate authority has been dealt with the matter in accordance with the law. Now, my lord, take trouble to the order of the appellate authority on that point. I just try to, my lord, assess your lordship so that your lordship can. I need not to go into the other, my lord, relevant portion of the order. My lord, order of the appellate authority. My lord, I'm referring your lordship, page 20 onwards.
20?
20.
20.
20, lordship.
Yes.
This appeal is against dismissal of the suit. Lord, I am stressing upon your lordship I have filed a suit for right title interest, suit for declaration and permanent injunction, as well as recovery of my khas positions from the
You did not to reiterate.
lordship. My lord, this appeal is against dismissal of the suit filed by the plaintiff appellant for eviction of defendant respondent a license in co-schedule dwelling house for 8 decimal and for declaration of the title in co-schedule property for 60 decimal. My lord, just stressing upon the two parts. First, my lord, 8 decimal of land.
I know that. That is not the I want your answer
Lordship.
on the point of
And
relation
for-
license and licensee. What is the decision?
And for permanent injunction against the defendant. Now, the plaintiff appellant has adduced relevant documentary evidence and registered Kovala dated 28 April 1943 as Exhibit 2 to prove his title in co-schedule property. The dispute is that defendant respondent has acquired title in entire co-schedule property for 60 decimal.
Sir, you don't need to read on that point. I know that. I want the specific point.
I
want the specific point. I know that. I know that.
Coming to the page 21, because this is continuation paragraph.
Not necessary. You just refer me the specific.
As the defendant respondent has claimed title in the suit co-schedule property by way of adverse possession, according to the settled principle that the title of the plaintiff appellant in the suit property is obviously admitted by the defendant respondent. Now it is to be considered whether defendant respondent has established his title in the suit property by adverse possession.
That was gone. That is no issue to together.
Lordship. Now, in this regard, page 21, in this regard, the learned court below has observed that there is a category of pleading in the written statement that Bipin Haldar, father of the defendant, forcibly entered into the suit property since 1365 BS, and also sons, daughters were born in the suit property, and his parents died there, and marriage ceremonies and his sons and daughters were performed at the suit vita.
Again, you are reading the entire fact. I want the specific portion.
I try to contradiction.
Regarding permissive possession.
I try to contradict to that. So far, the observation of the.
No, that is not the issue here. I have heard on that point. Why are you hesitating that point? I don't want this point to be again heard. I know that issue.
A matter.
Entire the adverse possession has been discarded by the learned trial court, and it was not filed cross appeal or otherwise. It was no there. There is no chance of raising adverse possession by the defendant now.
Correct.
So this is settled law.
Lordship.
So what are you arguing on this point?
No, I'm not arguing.
Then
I just try to.
No, you don't have to. I have said that I have read the entire matter.
Lordship.
You just want to. I want the matter.
Lordship.
Consideration of the learned first appellate court, where he has decided the issue, which was denied by the learned trial court regarding relationship between the licensor and licensee. Only that point.
No, Lordship, Janan cross appeal file hoyni seta niye kono proshno na.
Yes, that is settled. There is no issue of raise adverse possession of that. Nothing is there.
Only, my lord, few 2 or 3 minutes so that the matter will be clear. I think, my lord, if Lordship allow me, should I continue? 2 or 3 paragraphs, Lordship.
No, not necessary. You just come to a specific paragraph.
My lord,
You read last paragraph, page 24.
Yes, I'm relying the page 24.
Last paragraph, page 24.
I
have read it. What is your observation?
I'm relying the first paragraph and then
what is your submission on that point?
First paragraph and the last paragraph.
No, only last paragraph. Not necessary to argue on the first paragraph. I know that.
I'm reading.
Yes.
Admittedly, the defendant respondent in the possession of the co-schedule property, LR shows the defendant is in possession in the entire property, but possession does not confer any title, and it has admittedly been decided that defendant has not acquired any title in the suit property by way of adverse position. Matter comes to an end. Then how the possession of the defendant in cost schedule property is a legal right. But here, in spite of all this, learned court below has missed the prayer of eviction of the defendant as license on the ground that the plaintiff has not come before the court with clean hand. He has suppressed permissive possession of Bipin, father of the defendant, in respect of 4 annas of share in cost schedule, and has failed to prove induction of the defendant as a license with the PW2. The corroborate witnesses as stock and induction of the defendant as license has not uttered the name of the defendant in the cross-examination, who was deposed Bipin Haldar as a license under plaintiff. So far the PW2 is concerned. Should I be allowed to take the relevant paragraph?
No.
Relevant paragraph.
I have already read it. What is your submission on that point?
My lord, I again repeat, Lordship. The learned court below has dismissed the prayer for eviction of the defendant as license on the ground that the plaintiff has not come before the court with clean hand. He has suppressed permissive possession of Bipin, father of the defendant, in respect of 4 anna share in cost schedule, and has failed to prove induction of the defendant as license, where PW2, the corroborating witness as stock, and induction of the defendant as license has not uttered the name of the defendant in the cross-examination, who has deposed Bipin Haldar as a license under plaintiff. My lord, so far this paragraph is concerned, what I literally meaning, and so far I understood is concerned, my lord. My lord, if your lordship take trouble to the...
Yes.
My lord, in a suit, on the basis of, relying on the basis of registered deed, we have asking for, the plaintiff asking for the suit for declaration.
Again, you are arguing on that. I want your answer regarding the observation of learned trial court, which was reversed by the learned appellate court.
No, this is the observation of the appeal court.
Yes.
I'm reading.
No. You read thereafter. There is the observation of the learned appellate court.
Lordship. Then the settled principle, well, I'm continuing. Then the settled principle that civil cases, principle of preponderance of probabilities is applicable. Regarding burden of proof in the matter of license, the learned lawyers of the respondent has referred a reported decision in 101 CW 159, wherein the decision of Honorable Supreme Court in AI 1975, Supreme Court 1534, relating to the proof by preponderance of possibilities. In this case, it is clear in evidence that Bipin Haldar, father of the defendant, was licensed in respect of 15 decimal, and he died on 24th April 1984, though this is not pleading of the plaintiff. That plaintiff case is defendant that license under plaintiff in respect of 8 decimal only. The fact of Bipin has automatically, while evidence is folded before the court. This is to my mind, should not be considered by suppression of fact. My lord, this suit was filed before the court against the 8 decimal of land. But so far the RS record and others, some documentary evidence in respect of RS or LR is concerned, that 25% shareholder in respect of the...
Whether you support the observation of learned appellate court?
But obviously.
You support?
Yes.
Very good. That's all?
No, my lord, just I have to conclude this part, then your lordship can.
No, I have given you entire opportunity.
Lord,
you have again arguing on that point.
My lord, one thing.
These are not the issue here.
My lord, one thing. Just don't take me otherwise. Don't take me amiss also. My lord, a matter was taken up by your lordship in a piecemeal, different dates. Sometime your lordship heard half an hour, sometime your lordship 14 minutes, sometime. So your lordship desire was also this matter should be taken up on 10:30. Now, my lord, your lordship in hurried Your Lordship, don't take me otherwise, Lordship.
Not I am in hurry. I give you 5 minutes only to apprise this court regarding only specific point number 5.
Correct.
Then
I try to assess your Lordship, my Lord.
very well.
I try
Hard.
to. Lord, I have not completed my submissions.
Then why I want your answer from the beginning? You are not giving any answer.
My Lord,
You have not given any answer.
my Lord, your Lordship.
Sorry.
My Lord, your Lordship.
I may heard the matter in piecemeal, but I have fixed the matter for hearing only point number 5, not other than that.
My Lord,
I can tell you the entire evidence and entire record now also. That is not your difficulty. But I know the entire fact. I know what is the judgment of learned trial court, what is the judgment of learned appellate court. I want your answer.
My Lord, first point, so far question number 5 is concerned, which is Lordship formulated. Lordship, just. I again, let's conclude.
You cannot start again.
No.
Again and again.
I have restricted myself with regard to the only point number 5.
I have given you entire opportunity to argue on 4 days. You have argued on that point.
No, 4th day, I cannot come to a comprehensive, because, my Lord, when I have started, then, my Lord, time was no.
I have heard you. Very well.
If your Lordship, then
anything to say? Any judgment law?
Lord, I have not been completed my submissions.
I want the only answer. Question number 5 is only left.
Lord, I have started, then your Lordship's, my Lord.
No. That cannot be. That cannot be. I have given you entire opportunity. I have given you at least 20 minutes to apprise this court on point number 5.
So far, my answer, your Lordship. Your Lordship. My Lord, this question number 5 is concerned.
You are reading again and again.
No.
Paper
I'm not reading.
books,
I'm not reading.
order, judgments. I want your answer.
My Lord, so far the question number 5 is concerned. Yes. The lower court, appellate court, has the authority, and after recording the hearing the respective parties, and he can pass this order accordingly, and he has the full authority to ascertain the legality and veracity of the order passed by the trial court. There is no doubt he can do it. So far, the order of the appellate court can also be questioned before the higher court. In that,
you are arguing on other points. I want your answer on formulated question number 5, not the authority of appellate court.
The appellate court reversing the order of the trial court.
Yes.
So whether the trial court's order,
whether this observation of the appellate court is correct or not.
Yes,
only
correct.
This is the.
So
correct. That's why I want you are saying that correct.
Yes, it is a correct.
So what is why it is correct?
It is a correct.
Why it is correct?
Because,
that's why I want to know.
Because this order, this observation, appellate court observation in respect of this point of view is concerned, is correct. Because the trial court failed to ascertain the legality and veracity of the right title interest in respect of these on the basis of that, and the order of the claim of the plaintiff was simply turned down on the basis of without documents and without any depositions made by the respective.
Very good. Hard. Yes.
And so far the
reply.
So far the decision is concerned.
15 minutes, and I show your lordship the judgment as well as written argument also I will submit on that.
Very good.
So far the
file written arguments.
So far the decision is concerned, so that we can incorporate the decisions which are relying before lordship.
Okay, we can file the written argument and incorporate the decision. Please take down argument on behalf of the Masud Karim, state respondent. Respondent, state respondent. Argument on behalf of the respondent. Concluded. Let the matter appear in the list for reply on behalf of the appellant on 22nd of August 2020. 5 at 12:30.
Next item.
Your Lordship,
Now starting.
My lord, at 10. But I have,
Just wait.
sir, I should have precedence. My lord,
কখন
next item.
এটা when your Lordship fix this matter?
Sir, 10:30, my lord, kindly fix it at 10:30.
No, no, no. No 10:30. No 10:30.
And interim order be, my lord.
Okay, okay. Interim order passed by this court on the earlier occasion is further extended till 29th of August 2024 or until further whichever is happened.
My lord, the next
My lord, before rising, my lord, if your lordship takes up, my lord, item number 15, my lord, it is for extension of interim order, my lord. My lord, my other side is also present, my lord, extension of interim order. Group 8 matter, my lord.
Next matter is item number 4.
My lord, 4, my lord, may have some precedence tomorrow, my lord. My lord,
Tomorrow.
No, no, it should be there tomorrow because my lord takes it this up on Thursday and Friday.
Hey, দেখি
It will take only five
minutes.
এটা
ডায়েরিটা নিয়ে এসো।
সরি বাঁতে দিচ্ছি।
রাখুন ওটা, ডায়েরিটা নিয়ে এসো। দেখি তাড়াতাড়ি আসো।
কবে ডেট দিল?
কি আছে?
দাদা এটা কবে ডেট দিল?
কালকে 10:30 কিছু ফিক্স আছে?
I'll take 5 minutes. For our rejoin.
It will appear 10:30. What precedence you want? 1, 2, 3. All 3 matters gone. Now your matter will appear first.
My lord, item number 15, my lord, for extension of interim order, my lord.
My lord, item number 7, my lord.
Who is item number 6? So what would be done in this matter? They have seeking adjournments.
Next week or April.
Next week. Why next week? No, why not tomorrow?
I have no objection to them. My learned friend says.
No, it will. I cannot take up this matter. It will appear as it is at 12:30 tomorrow.
Your lordship,
Then
item
my lord.
number 21, there was a direction.
Right.
My lord,
By
instead
order
of tomorrow, my lord, it could be
19th.
next week, my lord.
Why?
Lord, I'm some difficulty, my lord. Mr. Join Gupta, my lord.
He will start first. Let them start first.
Then, my lord, he will conclude, my lord.
Yes, you start first. Yes, start first. You take note with a pen and paper.
My lord, so far item number 7 is concerned, my lord. It is my lord 10:30 matter, 12:30 matter. My lord, if tomorrow is taken up, my lord, I have no difficulty.
Tomorrow.
Yes, my lord, because my lord, tomorrow my interim order is also expiring. That's
Tomorrow I will take up this matter.
very well, very well.
21, there was a
That's good. No way.
My lord, item number 15.
Miller,
With
Miller,
the matter, my lord.
I can sit here for 3
My lord,
till 3.
my lord,
Like
item
that.
number 15, my lord, for extension of interim order, my lord.
When it is
But tomorrow, my lord, it is expiring, my lord.
item number 16.
15, my lord.
15.
15 and 16 together, my lord, 15. My matter is
Tomorrow under mention.
7138.
Tomorrow under mention.
Miller, item number 13, Miller, after leaving your court yesterday, I became sick. Miller, for reconstruction of the file matter, Miller, it's fixed in item number 13, Miller, for reconstruction of the file.
এই শোনো, এগুলো এখানে রেখেছো কেন? আমি এগুলো রাখতে বলেছিলাম। এগুলো রাখতে বলেছিলাম আজকে। মেনশন ম্যাটার তো আজকে রাখতে বলে। File not available. কালকে রাখুন, কালকে অর্ডার। It will appear tomorrow. I will pass the order tomorrow.
My lord, item number 15, my lord.
Much obliged.
Order, my lord.
I will
Grateful, Miller.
appear tomorrow.
Your lordship,
Tomorrow is the
item number
last day, my lord.
21.
Last day, whatever. Last day I will pass.
Your lordship, item number 21, there was a
Everything
direction dated 19th June to file their affidavit in opposition positively by 17th July, but till date they have not filed. Kindly their right to file affidavit in opposition be closed, Your Honor. This is
No, not like that.
Huh?
My lord, lordship will kindly not take me amiss. My lord, my client was very anxiety. Your lordship had made this matter CAB. So, lord,
Which matter?
this is lordship kindly sees this is that meteorological matter with regard to some weighing of the cylinders. Lordship had heard that extensively. That cylinders, some cylinders were found to be underweight. That matter. My lord had made the matter CAB.
Ready.
It's being ready.
It is ready.
It is ready. Very good. My client was
It
really
is
anxious.
this week. My PA is in otherwise on
my
leave.
lord.
And I was also not there.
Yes, lordship was not here for 2 weeks.
But it was ready. Ready 15 days ago, it was ready.
My lord.
Okay.
My lord.
Next week it will be
Get
definitely.
Much obliged.
My lord, may I be permitted to mention item number 3, Purana section 34. Matter had been fixed, my lord, last Thursday, 31st July, but your lordship did not sit, so therefore.
Yes.
The Mukherjee was supposed to address.
Argue on the matter.
Yes. My lord, today we are in some difficulty, my lord. Could it kindly be, my lord, kept on the 28th of August, subject to your lordship's.
Whether Mr. Surana is there?
My lord, we've given him notice.
You have given notice? Before notice.
Actually, we gave him notice first for yesterday, but then your lordship did not sit in the second half yesterday, and we again gave him notice for today as well.
You have also given notice for mentioning. Mr. Surana should be there. Hey, Edike show. So 41.
28th August, my lord.
20th August. No, 20th August is Wednesday.
28th.
28th.
Thursday.
21st, 22nd.
Some difficulty, my lord. Some difficulty, Mr. Mukherjee has some difficulty. He will take 2 days, my lord. 28th and 29th, he said he'll finish it, if those dates are available for your lordship.
December.
If your lordship wants to fix it on 2 dates, your lordship can do that also, no difficulty. 28th and 29th.
Fix nahi to. So better it I fix the matter for the first.
Very good.
On mentioning, item number 3 league, on mentioning this matter be urgent today. Cut. On the prayer of the learned counsel appearing on behalf of the respondent, the matter be urgent today. List the matter on. List the matter for peremptorily on 28th and 29th of August 2025, specially fixed at 2 p.m. for argument on behalf of the respondent.
But could it be right at the top of the list, subject to your lordship's convenience?
It is the first.
Most straightforward.
Call the list.
It's my fault. Or
Why?
as a victim of circumstances. One matter, part matter was fixed in code number A in the division bench. Now I have heard the Navanno vision matter is being taken up by that court, so I will be little late. So I request Mr. Srisana Bandhavada not to do this matter. Now I am free. He cannot be. I cannot blaming him. Kindly keep it any day next week.
Next today, it would appear on Thursday.
Thursday, first
14th.
Deleted his position Thursday.
Thursday. Only not today.
We are filing the exception today or
no on that.
On that.
Sir, may I have a copy so that I come prepared on the next day? Copy down. Deve na.
I will
let it.
I will settle it.
Okay.
By default participant.
Call the list.
My lord, before my learned friend starts, my lord, I would seek, my lord, an extreme indulgence. My lord, if my learned friend concludes today, kindly give me, my lord, an opportunity on some other day, my lord.
Let him conclude first.
Because I have a, my lord, matter before the division bench. I just came for this.
Okay.
At 2 p.m., my lord, I'll take your lordship's leave to go there, my lord.
Okay,
But
you can, someone should.
yes, my juniors are there.
Very
Yes.
Let him finish first.
26 না 26 তো করলে ভাবলাম শুরু থেকে 26 পাঠাবো আমার ভাগ্যই খারাপ যাচ্ছে কি যেন এটার নাম টোটি আমার কাছে ব্রিফ আছে ব্রিফ দাও now my lord, on the last occasion my lord,
yes,
but I'd been showing
supplementary family settlement
my lord,
dated 29th September 2009.
yes my lord, I'm very grateful my lord. My lord, that was the first supplementary agreement.
There are another supplementary.
There is another one.
Okay, that I do not know.
My lord, what I wanted to, what I'm trying to, my lord, establish before your lordship that all these MOUs were made with a lot of thought. It's not just an offbeat, it's just made one night and it's finished. They're made with a lot of thought, trying to get to an end of this dispute, my lord. My lord will kindly see page 63 of my lord, the 63. One kind takes page 63. 63 G একটাই তো G3. হ্যাঁ
Better copy 63A.
Yes, my lord, 63 is the typed copy, my lord.
Second supplementary memorandum recording.
Achha, second supplemental memorandum recording family settlement. Made this first day, my lord, again the parties your lordship will find. It's again that those parties. And then, my lord, next page, to the middle of that page, my lord, page 64, after third part, if your lordship kindly sees, Ace Impex, Akshay Vinimay Private Limited, Srishti Developers. They were known as the first confirming parties. And then fourth part, at the very bottom, is one Star Trade Goods Private Limited, which was the second confirming party.
Started Goods Private Limited.
My lord.
Fourth part.
Fourth part.
Second
It's after the fourth part, my lord. First confirming parties are the fourth part, because my lord, there are three groups. Then first confirming part is fourth part, and Star Trade is the fifth part.
Yes.
Now, my lord, kindly takes page 65. My lord, first recital records the first agreement and the first supplemental agreement.
Yes.
Then, my lord, kindly sees, my lord, just after that, now this second supplemental, number one, that have been done. Each of the parties confirm and agree that the RK group has contributed the entirety of its proportionate share of investment under contribution, costs, expenses, and the liabilities. Both outside party and intergroup also received its proportionate shares of the receipts as well as shares of profits of and or towards each of the aforementioned confirming parties, namely Ace, then Akshay.
So it is RK group.
RK group, madam.
Yes.
So, my lord, this is the defendant number 2, who is, my lord, ascertaining that he has contributed the entire of his shares in respect of Ace and Akshay. Then, my lord, next page, it is also recorded that as on 12th September, there were monies payable and receivable of the aforementioned confirming parties to various family companies falling under the allocation of PK and NI.
Yes.
For as mentioned in Annexure A of the MOU. Now it refers to the first MOU. as well as to any other outside parties further recorded mutually agreed by the parties. As part of the MU, the RK group shall not be liable to pay and receive its proportionate share of any dues payable and monies receivable by the aforementioned confirming parties to or from any parties for the period up and until the 12th of September. Yes, so, Malak, this was the third agreement between the parties.
Yes.
Now, Malak, obviously, your Lordship will kindly appreciate that this third supplementary affidavit, third supplementary memorandum,
yes,
Malak, also shows that the parties had already started acting on the basis of the first MOU. Now, Malak, on the basis of this, Malak, on the basis of the first MOU, Malak, the affidavit of assets is filed in the probate application. Now, Malak, my learned friends, then obviously, Malak, they come and file a caveat, Malak, it's not in dispute. In this, Malak, they file an opposition. But we'll kindly see the first opposition of Mr. Pawan Kumar Todi in GA number 3. To Devan, please. Opposition to the date, however, 25th March 2025. Opposition. देखिए एक बार देखिए राजकुमार टोडी है नहीं এটা না पवन कुमार टोडी তো দেখুন ডিফেন্ড নাম্বার 1 হবে হ্যাঁ হবে এত তো পাতলা নয়
এরকম মনে হবে
বুঝতে পারছি না G3 লেখা আছে ওইটা হ্যাঁ বলবো পড়ে না দিস
affidavit in opposition on behalf of the defendant number 1.
Defendant number 1.
Caveated.
Now, my lord, kindly sees paragraph 4. They say that the plaintiff has knowingly made incorrect statements in the application with the intention of expanding the scope of this probate proceeding, abusing the process. The executive acting in a malafide manner and trying to bring in issues which serves his personal agenda. The executor taking advantage of his position is missing his legal right. Then, my lord, 6. Excuse me a moment, my lord.
Yes.
Now, 6, my lord, kindly sees B. The petition for probate as served requires the executor to state the amount of assets that are likely to come to the petitioner's hand. Affidavit assets includes the assets which the testator had during his lifetime dealt with, as more fully stated here in below. So, my lord, the contention is that the testator has already dealt with these assets. 2009 was the settlement.
Yes.
Where it was mentioned that no parties can act beyond this. And then they say that it has already been dealt with. So, my lord, now a title dispute is being attempted to be raised by my learned friend's client. I am absolutely aware and I also endorse, my lord, the probate court will not decide title. But to what extent the probate court, till the probate is granted, my lord, appoint an administrator and also injunct any third party from alienating or, my lord, affecting any properties mentioned in the affidavit of assets. That is what I will try and establish with your lordship. I'll refer to several judgments, my lord, starting from 1951 and now at the very end, my lord, in the Birla matter, your lordship knows now the Birla matter is the most known, my lord, probate proceeding litigation. So therefore, my lord, I will rely on that also to show that yes, such injunctions can be passed and ought to be passed.
Yes.
If I can establish, my lord, that they are dealing with the property. One of the first statement which they make itself is a statement which attacks the will. Why do I say this, my lord? The will is very clear that it falls back on the memorandum. Now they say they have a caveatable interest, comes in, opposes the suit, opposes the probate, and then says that these are not the properties of the testator. This is the position. When coming in for a caveat, they say yes, everything is fine. Now they say that no, these are not caveat, these are not the properties anymore because they've been dealt with. Malab will kindly see paragraph 6b. Having knowledge of the same, the executor purposely included property not forming part of the estate of the testator. Malad, may I just wait here for a moment? Malad, I am making two submissions. You will kindly keep it of note. To say that a property is not the property of the testator is one thing. But to say that the property was of the testator but has been dealt with is a separate thing to say.
Yes, I understand.
So that is what they are saying. They are saying it's no more. They are endorsing the first MOU, no dispute about that. But they said it has been dealt with. And for that, I will show they are relying on an agreement suddenly brought into existence in 2019, they say. I'll show that. Now, can you see? Now, the attempt of an administrator appointed of the same is to involve the same in litigation. Use the process of court to interfere with the rights of the rightful owners. Thus, the executor trying to take wrongful advantage. Challenging the said proceeding, answering given has filed his affidavit in support of his caveat and it has been converted. 1 and 2 are brothers, while the mother of the plaintiff, Shushma, I've shown this. Now, it sees E. They endorse that there is a family settlement 28th September. But that's the same. But I'm just trying to show the prima facie case before your lordship. If you endorse that, then you can't say it was never the property of the testator. Then supplemental memorandum in 29th were executed.
Yes.
And copies of the memorandum of the family settlement agent. Excuse me. So let's see, there are 2 supplementals also. Kindly then sees all the parties aforesaid had signed each of the above mentioned family settlements, adhered to, acted upon the same and made representation of the world at large about their respective estates, independent and severable from each other. I think that would be severable, not several.
Yes.
On the basis of such settlements. In fact, the said Shushma Bajoria had made a specific and categorical declaration of having given up all rights, interest, title, interest of every nature in the estate of her father and her mother, Shanti Devi Todi. Malad, this, according to me, Malad, is a completely wrong statement. It only said for the purpose of settlement, I pointed out then also. For the purpose of settlement, Shushma was being included into the group of the testator.
Yes.
That is what it said.
NL group.
NL group. But that does not mean that if NL passes away, Shushma will have no rights in NL's property. The intention is very apparent. Throwing out everyone. Take the property. That is what is happening here. And next, I'll point it out. Then, G, throughout their life, NL Todi, wife Rajkumar Todi, herein, after having taken his share of the assets and property, separated for all intents and purposes and started living separately. Then Shushma was married. Then Shanti Devi and Nandalal Todi died. This is very unfortunate during COVID. Then, is the most important paragraph. The said Nandalal Todi and Shanti Devi Todi. Nandalal. During their lifetime, by various deeds and documents, dealt with the assets and properties, including the shares held by them, individually in certain companies, fully and absolutely in favor of his eldest son. The different number 1 hearing. So, my lord, the father and the mother then decides to give everything to the defendant number one. That's what the defendant number one says.
This is the statement.
This is the statement. And then, my lord, he relies upon a deed, memorandum recording settlement dated 4th June 2019. This is Annexure C. I'll just take your lordship to that page, but first let me just complete two more paragraphs and then I'll take your lordship there. Such fact is a notice and knowledge of the other two children of the said Nandlal Todi, namely Shushma and Rajkumar, who had accepted the same without any protest. Plaintiff is aware of the same. The said Nandlal Todi at the time of his death did not hold any unlisted shares of any company. It would be borne out in evidence from the last income tax return filed on 10 December 2020, prior to his demise being for the financial year 2019 and 2020. And they are relying on an income tax return to show that he did not hold any shares. So basically, they are asking the probate court to hold on the basis of income tax returns that the properties have been transferred to them and the Nandlal is no more the person concerned. This, I think, is a bit far-fetched in a probate proceeding, which they are asking for. Then, it is only after the death of the parents of defendant 2020, the two now disgruntled siblings of the defendant number one have started targeting the defendant number one in a bid to extort some benefit by filing false and frivolous litigations. The memorandum of 2019 was between Nandlal and Pawan Kumar, where Nandlal transferred all his residual shares and rights over various companies and properties to Pawan Kumar post signing of the settlement and prior to his death. Now, my lord kindly appreciates when the group, as a group, is being bestowed with certain rights and properties by the memorandum. My lord kindly appreciates that Shushma is also a part of it.
Yes.
My lord, why they are saying this? My lord, this sentence is very important because if Shushma is included, Shushma is not a party to that. For Nandlal to transfer, whatever has come to Nandlal is along with the shares of Shushma.
As a group.
As a group. So Nandlal to give what he has got as a group would need also Shushma. So that's why from the very beginning they say Shushma is nowhere. Nowhere there. Now, let's see. This memorandum recording data is part of the records of the civil suit of 2022 before Alipur Court filed by Neeraj Bajoria and Rajkumar Todi is also one of the defendants. So, this was challenged. Now, Nandlal Todi died on 15 November 2021 and prior to his death, he transferred all his shares into Pawan Kumar Todi by filing share transfer forms with the Register of Companies. Raj Todi oppose করেছে নাকি 4th June. What is his name? সেটাই তো বলছি opposite চ্যালেঞ্জ একই জিনিস. As a matter of fact, my lord, the defendant number 2 has also challenged this memorandum of
4th June 2019.
Who is also a caveator before your lordship. Now, my lord, Nandlal died on 15 November and prior to his death has transferred all his shares to Pawan Kumar by filing share transfer forms. IT returns prior to his death also did not reflect the share in companies, I think claimed by Bajoria Group and Rajkumar Todi Group. Now, my lord, kindly see, it's very interesting. A new group comes in now. There is a Bajoria Group. That's Shushma, my lord.
Okay.
Shushma has now been made into a Bajoria Group.
NL Group is now named
Bajoria Group.
Bajoria Group.
So, as would be evident from the annual returns for the year 1819 and 1920, reflecting the shareholding patterns of Akshay Vinimay LLP, as claimed by Bajoria Group and Rajkumar Todi Group, will make it evident that Nandlal Todi never held any shares, nor was a partner in that entity, even during his lifetime. A copy of Form 11 being the annual return for the year ending are annexed here too. My lord, may I just pause here? I wanted to only show this, my lord. So what are they saying? That with regard to Akshay Vinmay Private Limited, he did not hold any shares. My lord, if he did not hold any shares, these are mentioned in the deeds of 2009. They have not challenged the deed of 2009.
Family settlement.
No one has challenged it. Then why did you allow that to be in that 2009 deed? If he did not have any shares or was not a partner, how did Nandalal get the 25, 50, 25 shareholding there?
Yes.
Now you are coming and saying all these things, but you never challenged it. In 2009. Then Malat, can you see? Then they talk about Malat, another recording settlement. This is very interesting, Malat. After the probate proceedings, Malat, there were talks of settlement.
After the present probate proceeding?
Yes.
Okay.
But obviously, Malat, there are disputes all around now. So there were attempts to settle it.
Yes.
But again, Malat, on instructions I'm saying, my client has been again backstabbed. So, Malat, again, residual steps, whatever are required to be taken is being taken. But let us see what they say. Now they say, Malat, there is another agreement of 2024. And that's Q.
Yes. 28th March.
28th March 2024 was entered into by and between Narendra Kumar Bajoria, Sushma Bajoria, Neeraj Bajoria, and Pawan Todi and his sons. A copy of the said memorandum of 28th March 2024 is annexed and marked as F. The Bajoria group had accepted and confirmed the settlement dated 4 June 2019 with Nandalal and Pawan Kumar disclaiming their right over such properties as stated in the settlement of 4 June 2019. Well, that was the consideration. In the subsequent 2024, it was that we'll settle everything. You accept that, Nandalal giving to Pawan, though it is in dispute, and it's a global settlement. But Malat, it has fallen through. But in this opposition, Malat, in spite of that falling through, they are trying to enforce it before your lordship to require your lordship to hold that these are not the property of the testator, being a probate court.
Yes.
This is the situation. Malat, we had always learned that if you're a caveator, you take what the testator is giving you. You can't dispute the title of the testator.
Yes.
That is the principle, first principle. So, Malat, we find that he is continuously doing that here, whatever it is, Malat. Then, Malat, as a matter of fact, just after that, there are, Malat, several, Malat, suits which have been filed, have been recorded. I will come to this later, Malat. First, may I show, Malat, that first agreement of 2019 which they are relying upon.
4th of June.
Malat. I think I'm also coming down with the common bug, Malat. Everyone's voice is having a problem. তারপর কি নিয়ে নেবো তোমার ওটা কোন পাতা বলো হ্যাঁ এটা তো 68 তো মানে kindly take page 68 of the opposition matter. Well, this is, they say, is between Nandalal Shanti Devi on one hand and Pawan Kumar Todi on the other hand. Malat, again, Malat, I beseech your lordship, Malat, the first 2009 MOU clearly said Nandalal, Shanti Devi and Sushma Bajoria would be the first part.
NL group.
NL group. Here, my lord, we find only Nandalal and Shanti Devi coming in and entering into this agreement. But my lord kindly sees the first recital. Parties from time to time executed the following documents evidencing and recording family settlement. My lord, that is 2009. 2010 একটা কি হবে? এখানে 2010 লেখা আছে। ডেটটা ভুল দিয়েছে বোধহয়। Then, my lord, that as on that the date hereof there exists no company, firm, partnership, limited liability, Hindu, Nidhi which is held jointly and collectively by any or some of all of the partners and parties. But how can this be said? The MOU clearly recorded that there will be certain companies and certain lands where they would have 25, 50, 25.
All the memorandum of recording, there are 3 groups.
Yes.
In the year 2009 and 2010.
I showed to your lordship, my lord.
Yes. But now they are saying that they are entered into some earlier agreement.
Saying that as of today, there is nothing which is jointly held. But my lord kindly sees 2009 clearly said there would be some which will be jointly held in shareholdings, as in ratios 25, 50, 25. How could this be done? And Sushma was a party there. Sushma is not a party here. Now kindly sees. Now this memorandum, this is the habendum, my lord, page 71.
Yes.
Disclaimer of rights, very easy. The first part is hereby disclaims all right, title, interest, claims, howsoever, whatsoever on the following properties. So, my lord, Shodhpur goes, AJC Post Road, Beleghata property, and Todi mention. Where, my lord, the first group had 25%.
Inspiration. Now this court has to decide group of companies doctrine like that.
And at this moment, my lord, even lesser than that. I am on a different platform now. Group of companies, the parties have agreed.
Yes.
They have agreed to the shareholdings, my lord. Not as a shareholding as in shares. The share in the property is 25, 50, 25.
Yes.
That had shown your lordship schedule. Now, who were in the first part? There were 3. Here, one is not there. Sushma Bajoria is not there. How could the first part say this? Or first part be the first part, where the first part is in variance with the agreement of 2009? Shantira Shoynato. And my lord, may I just show one more thing very important, my lord? Before I go to the other, my lord, clauses, my lord will kindly see here at page 73. Nandalal Todi for himself and Shanti Devi Todi. This is the signature, my lord. Nowhere is it spoken about any part or anything. Nandalal for Shanti Devi. Has lordship found that? I'm absolutely right.
Yes.
Signed and delivered by the first parties at Kolkata. And Nandalal signs for himself and Shanti Devi Todi. And this is their primary document, whereby they say that they have a right to deal with the properties. Isn't it?
Not by Nandal. This one, Nandal to design.
Where is this confirmation later?
Yes.
joint compromise petition. The first parties further clarify and confirm they have relinquished all their rights to the above properties. I am reading from B, my lord. না এটা কি করে হয় 29 2014 এর কথা বলছি নন্দলাল from the family settlement thus not retaining any such rights shall not claim any rights in the future. The first parties further confirm the joint compromise petition filed on 3rd December in the court of the learned second civil judge Shravan Kumar Toti was none other than the members of the first parties had transferred and disclaimed all their rights holds true and valid even today. Where is that? Then the first parties further declared and confirmed that the affidavit as filed by first party number 1 on 18th August 2018 entitled suit number 857/2018 was done under immense pressure exerted by the members of the family of Mr. R.K. Toti. That's the defendant number 2. And the first party number 1 expressly withdraws and rescinds all that is written in such affidavit. What is this going on?
Evidence of coercion.
Against the defendant number 2, my lord. Huh? No. I did. May I come back on another day? Some voice problems.
Okay. No issue. Next
May I take your lordship's kindly for a minute?
Yes.
Yes, my lord. But many people are kindly gives you 1 minute. I'm just coming.
Okay. 21st কি আছে দেখো তো 21st নাই তো okay 21st
Well, 21st. Look, I don't have any difficulty. My interim order is there till 22nd. Yes, in case, my lord, we'll extend it just for 7 days thereafter, so that there is no risk, my lord. Only till the end of August. Last time, my lord,
I'll
till the
pass
end
the
of
order on 21st then. Very good. Argument on behalf of the petitioner. Plaintiff continues. Let the matter appear in the list on 21st of August 2025. Special fixed at 2 p.m. For further argument. Okay. Obliged.
Report I am appearing for respondent number 5, Your Lordship.
Petitioner has concluded.
Your Lordship, I think state was
Yes. State supposed to argue today.
Your Lordship.
You have got the entire documents.
But the only difficulty is that original affidavit filed by the state, I've got a copy from my learned friend, but I find from the records that has not been available in the records.
Is it? I've seen that. The record.
Having opposition filed by the state in 2017. If my lord permits us, then we can reaffirm it.
Mention করেছিল opposition.
My Lord.
আপনি স্যার opposition নেই ডিপার্টমেন্টে কি আছে কপিটা অরিজিনালটা নেই অর্ডার আছে রেকর্ড বলে রেকর্ডটা দাও দেখো অর্ডার এরকম
My lord, I'm appearing for the petitioner. My learned senior counsel is coming.
I am for the respondent number 5. Petitioner has concluded argument. Today is the turn of the state.
My lord, the affidavit on behalf of the state was affirmed long time back and copy was served to us. It is not clear whether advocate record has filed the affidavit in opposition in the department, because in original such department also takes the affidavit. It is not that as and when matter called the bench is filed.
Is filed in the department.
In the department. No, since it is a writ petition, sometimes the court is liberal on that point. But thing is that on the basis of their affidavit, which was served to us, we have submitted that copy to your lordship also. And we have
Is there any order like that? The affidavit is missing or not placed like that?
Not at all. The learned, if the affidavit, this could have been done long time back, my learned friend can, even my lordship can give an liberty
Reaffirm this.
to affirm, but in the meantime, the hearing can be proceeded. There's nothing wrong, because it's a long time.
Let me check out the records, order books.
And pursuant to your lordship direction, I have duly served copy of the writ petition.
That's why I have asked whether you have received all things.
I have duly served all entire reply, everything.
স্টেটের ওটা নেই না আমরা সেটাই আমরা চেয়েছিলাম 2-3 বার আমরাও পাইনি স্টেটের ওটা ওদের কাছে তো আছে স্টেটের My learned friend has the AO of the state.
I have submitted that, a copy of that.
This copy is also in the record.
Yes, that's on record.
Copy, but original, where is the original?
Original.
That's why I'm asking. Have you served the copy?
Yes, everything.
আমাদেরকে একটা দিয়ে দেবেন একটা copy.
But thing is that, my lord, this advocate record office is fully functional. Until recently, they have received all communications.
Yes.
And advocate record has not come forward to say that whether the affidavit has been filed or misplaced. We have already filed reply long time back.
ফাইল হয়েছে কিন্তু ফাইল এখানে ওটা বোধহয় দেয়নি ওটা রেকর্ডে ছিল হারিয়ে গেছে
And this Xerox copy can be relied upon because in every page there is an endorsement of the commissioner who affirmed the affidavit.
This was forwarded to him on 22nd of December 2017.
Long time back. And even if it is misplaced, there is an endorsement in every page of the commission.
Proceed on that matter.
Yes, madam. There is no problem in proceeding with.
Okay, let's start hearing. Give me the writ petition.
I'm deeply obliged.
Noting টা দাও আমার noting টা দাও
Got the copy of the request.
I don't have extra copy at the moment.
Copy of AO.
No, copy of the writ petition.
Yes.
On page 103.
103.
On a date of affirmation of the petition, when it was affirmed on 18th August 2017. Bottom.
18th August 2017.
18th August 2017. Writ petition has been filed.
Yes.
This was what I can see. Section 3(1) of Act 201 of 1948 was issued on 24th of November 1971.
Act 1 or Act 2?
Act 2.
Act 2.
I have got a copy of that. I have also got a copy of the Act.
Yes, I
I've
have
got-
a copy of Act 2.
Yes.
Act 2 কোথায় গেল? এখন 1948 Yes.
We also got it.
Give me a copy. বই দিচ্ছি।
Under Section 3(1) notice. Section 3(1) was kindly see. If the state government, have you also got it?
Requisition.
Requisition.
Yes.
Under 3(1) notice issued on 24th of 1971.
In this matter.
In this matter.
3(1)
And-
notice.
And we have taken possession on 6th December 1971.
So notice date.
Under Section 3(1)
Date.
on 24th of November 1971.
24th of November 1971.
Yes.
Taken possession.
And possession on 16th December 1971.
16th December 1971.
And then Malad, notification under Section 4(a) was issued on 3rd October 1981, and that was published in the official gazette. That is at page 118 of the paper of the petition.
Notification issued date.
Yes, under Section 4(a), and page 118 of the petition.
4(1)(a).
Yes. Oh.
1 small a. Page.
Page 118.
118.
Third October 1980. And handed over to the KMC. And 18th of March 1981, when a notice under Section 5(1) and Roman 3 of 1948 was issued to all the person interested to submit their claim regarding compensation or objection.
Page.
On page 121 to 122.
Annexure P3 and P4.
I prepared a notes on that. I'll hand over to your lordship.
Yes.
Yeah, page 121 to 122. Have your lordship got it?
Hearing notice.
Yes.
Yes.
Then on the 1st May 1993, a representation was made for compensation. Then another representation on 4th June 1993. And for payment or for declaration of award. Then on 19th June 1993, this was transferred to National Science Museum. It's called Science City. What about the pleadings made in the petition last time placement? In 1993, rate petition was moved before this Honorable Court challenging this acquisition proceedings and payment of compensation. Then my direction was issued by this honorable court to complete the proceedings and pay the compensation. Then on the 31st of March 1994, that is at page 133. Page 133.
Yes.
Sorry, 31st March 1993, this Act of 1948 was amended. Kindly see page 133, section 2. Amendment of section 1 of Act 2 of 1948 in subsection 4 of section 1 of the West Bengal Land Requisition Acquisition Act 1948, herein that referred to the Principal Act as reenacted by the West Bengal Requisition and Acquisition Act 1917. For the words, figures, and letters, the 31st March 1994, the words, figures, letters, 31st March 1998 shall be substituted. Have Lordship got it?
Yes. So the date has been changed.
But the date has been
extended
till 31st March 1997. Then on the 27th of October 1995, award was published. Paragraph 9 of the affidavit in opposition of the state.
Award was published when?
27th October 1995.
Yes.
Kindly see then 8th October 1996, that is at page 175. And Act 1 was amended so far as West Bengal is concerned, because presidential assent to the Act of 1940 was section 9(3) and 3(a) was incorporated.
Yes.
This is an admitted position. Now, we will kindly consider 22nd of May 1997, page 175.
Page 175 AO?
No, of the writ petition.
Not 175.
Just a copy. What is this? Correction.
Second volume আছে এটা second volume টা দাও writ petition এর second volume
Most probably in the second volume.
Second volume.
Page 175. ওটা তোমারাই বলেছো।
না এটা কি দিলে? Yes, volume 2. Page 175.
175. That Act 1 of 1894 was
West
amended.
Bengal Amendment Act.
This amendment was incorporated and this section 9(3)A and 3(b) was in. I'm not making any submission because this is an admitted position.
Yes, this is admitted.
Then, Malat, page 138 for a moment. Award was published.
Yes. Award was published.
Award was published. Gentlemen, Lord, that is 31st March 1995.
Yes.
But there was a reference, your lordship knows, under the Act of 1948, section 8, and corresponding section 18 of the Land Acquisition Act, that if somebody is agreed by the award passed by the collector, he can make a reference. Then a reference was made.
Reference to the reference court,
civil
district court.
Alipur court.
Yes.
Civil judge, LA judge, civil court. Then 23rd December 1997, acquisition proceeding completed.
23rd December, award passed.
Yes.
LA proceeding concluded.
Concluded. And when the reference court passed the award on 28th of June 2021, paragraph 25.
Enhance the award.
Enhance the compensation.
Page?
On para 25 of the retreat. But this is an admitted fact.
Okay, okay.
Then when the corporation, now my lord, kindly see that if reference court passed an order on 28th of June 2001.
Yes.
Sorry, sir, 201.
28th of June 2001.
One. I have pressed before the lordships when the writ petition was filed. Writ petition was filed on 18th of August 2017.
Writ petition
was
filed
filed
on 18th of August 2017.
And why I have pressed before lordship this? But the writ
Just draw the entire analogy. Entire analogy for completion of the entire LA proceedings and the completion of the reference court's decree.
Yes. But now the
in the year 28th of June 2001.
Yes.
Now they have appeared before this court in the year 2017.
17.
After 16 years.
One of the writ court limitation act does not apply, but it must come within the reasonable time. Whether the writ petition could be entertained by this honorable court. First point.
Yes.
No. Now one of the your lordship will kindly consider whether the writ petition could be entertained by this honorable court after a lapse of 16 years or 15 years. There is no reasonable explanation why there is a delay, inordinate delay.
Yes.
64 something. This has been discussed by a division bench, a constitution bench of the Supreme Court, and also by a Supreme Court. I'm just angry. Second. Well, 2015 SSC page 602. 2015 volume 15 SSC page 602.
Paragraph
paragraph 20 to 28. Have you also got it?
Yes.
May I permit to place it? Having stated thus, it's used to refer to a passage from the City and Industrial Development Corporation, wherein this court, while dwelling in the jurisdiction under Article 226 of the Constitution, has expressed thus: the court, while exercising jurisdiction under 226, is duty bound to consider whether adjudication of the writ petition involves any complex question or disputed question of facts, and whether they can be satisfactorily resolved. But here his question is, during the pendency of the writ petition, after acquisition of the proceedings, we have transferred the property to the corporation. Corporation transferred the property to some other party. But this deed may not be challenged before this honorable court, because deed has to be cancelled. A writ court cannot decide the deed in exercising jurisdiction under 226. And whether deed has been rightly transferred or wrongly transferred or validly transferred.
There are some disputed questions of facts.
The petition reveals all the material facts. Petition has alternative remedy for the resolution of the dispute. Person invoking the jurisdiction guilty of unexplained delay and laches. This is a D, small d. Expressly barred by any laws of limitation. Here is the D and E, my submission. Grant of relief is against public policy or barred by any valid law and host of others. In this regard, reference to a passage from Karnataka Power Development Corporation would oppose it. Delay or laches is one of the factors which is to be borne in mind by the High Court when exercise their discretionary power under Article 226. In appropriate cases, the High Court may refuse to invoke the extraordinary powers if there is such negligence or omission on the part of the applicant to assert his right as taken in a conjunction with the lapse of time. And but kindly see the lapse of time, because lapse of time, transfer has been made, taken place, and other circumstances causes prejudice to the opposite party. After so stating, the court, referring to the authority in state of MP versus Nandalal Jaiswal, written the principle articulated in the pronouncement, which is the following effect: the High Court, in exercise of discretion, does not ordinarily assist the tardy and inordinate or acquiescence and lethargy if there is an inordinate delay on the part of the petitioner and such a delay is not satisfactorily explained. The High Court may decline to intervene and grant relief in exercise of the writ jurisdiction. It was stated that the rule is premised number of factors. The High Court does not ordinarily permit a belated resort to the extraordinary remedy because it is likely to cause confusion and public inconvenience and bring stain to new injustices. And if the jurisdiction is exercised after a reasonable delay, it may have the effect of influencing not only the hardship and inconvenience, but also injustice on third parties. But kindly see the language. Injustice to the third parties. Although I am appealing for the state, why limitation is after the date of acquisition and making over possession. If acquisition is declared to be valid by this honorable court, or for a writ petition is, my contention is not accepted by the court, then the question will be decided by your lordship. It was pointed out that when the writ jurisdiction is invoked, unexplained delay coupled with the creation of third-party rights. Well, kindly see. It was pointed out that when the writ petition is invoked, unexplained delay coupled with the creation of third-party rights in the meantime is an important factor which also weighs the High Court in deciding whether or not to exercise such jurisdiction. Am I clear to your lordship?
Yes.
In state of, next paragraph, in state of Maharashtra versus Digambar, a three-judge bench laid down the power of the High Court to be exercised under Article 226 of the Constitution. If it is discretion in exercise, must be judicious and reasonable, admits no controversy. It is for that reason a person's entitlement for relief from High Court under Article 226 of the Constitution, be it against state or anybody else, even if it is founded on the allegations infringement of legal right, he has to necessarily depend upon the the conduct of the person seeking relief, and the court refuses to grant discretionary relief to such persons in exercise of such power when he approaches with unclean hands or blameworthy conduct. Recently in Chennai Metropolitan Water Supply and Swaraj Board versus T. Boroli Babu, that the doctrine of delay and latches should not be lightly to be brushed aside. A writ court is required to weigh the expansion offered and acceptability of the same. The court should bear in mind that is exercising extraordinary equitable jurisdiction. As a consequential court is a duty to protect the rights of the citizen, but simultaneously it keeps itself to the primary principle that when an aggrieved person without adequate reason approaches the court of his own desire or pleasure, the court would be under legal obligation to scrutinize whether its lease at the belated stage should be enforced or not. Be it noted, delay comes in the way of equity in certain circumstances. Delay and latches may not be fatal, but in most circumstances, idoneated delay would be only invite disaster to the litigant who knocks at the doors of the court. Delay reflects the inaction on the part of the litigant. A litigant who has forgotten the basic norms, namely the procrastination is the greatest of thief of time. Second law does not permit to sleep and rise like a phoenix. Delay does bring an hazard and causes injury to lease. At this juncture, we are obliged to state that the question of delay and latches all kinds of cases would not carve the cartel the part of the writ court exercise the discretion. Then, my lord, delay and latches is adopted as a mode of discretion to decline exercise jurisdiction to grant relief. There is another facet. The court is required to exercise judicial discretion. The said decision is dependent on the facts and circumstances of the case. Delay and latches is one of the facets to deny exercise of jurisdiction. It is not an absolute independent. There can be mitigating factors, continuing cause of action. That apart, the whole thing, it sucks the judicial concerns. Then the court should exercise the judicial discretion more so when no third party interest is involved. But can't see, if no third party's right has been involved, then it would be. But here is third party right has been accrued. Thus, analyze the petition is not hit by the doctrine of delay and latches. As I say, what just like section 22 of the Limitation Act, continuing cause of action. A pension, somebody is not getting pension. It is a continuing cause, or somebody is not getting higher pay scale, or somebody is not getting the incremental benefits. It's a continuing cause of action. But this type of right to the property, acquisition proceedings, as soon as the award is declared, reference made, chapter closed. But cause of action starts from there. And there is no explanation why such a delay.
Yes.
No hard and but because a larger bench judgment has been delivered, so doing that, cause of action cannot be even. No hard and fast rule can be laid down as to when the High Court should refuse to exercise jurisdiction in favor of a party who moves it after considerable delay and is otherwise guilty of latches. Discretion must be exercised judicially and reasonably. In the event that the claim made by the applicant is legally sustainable, delay should be condoned. In other words, where the circumstances justifying the conduct exist, illegality which is manifest cannot be sustained on sole grounds of latches. When substantial justice and technical consideration has pitted against each other, the cause of substantial justice deserves to be preferred, for the other side cannot claim to have a vested right in injustice done because of non-deliberate delay. The court should not harm innocent parties if the rights have been in fact emerged by delay on part of the petitioner. Besides, in the said case, the appellants were deprived of the dues of the dues. Kindly see next. Paragraph 27. The grievance against the respondent did not deserve to be addressed on merits. Doctrine of delay and latches hardly visited this claim like chill of death, which does not spare anyone, even who fosters the idea and nurtures the attitude that he can sleep to avoid death and eventually proclaim Dio Gratis, thanks to God. I should not. No. হুম? করে করে মাপলে করে যায়। হুম? এরকম ভাবে কি মামলা করা যায় নাকি? And there is no denial of the facts. They have received the awarded money in respect of some persons.
They have received none.
Money.
They have received the award money.
Today, holds against the state. Will they refund the money? If they refund the amount, can it be refunded and set aside all the transactions or transfer of this right in favor of the third party? And we have established a science city, public purpose, just on the side of the Eastern Bypass, near Park Circus connector. Now, this is one of the factors.
No, this writ petition is only based on two grounds. Number one, the proceeding has been lapsed.
No, I'm not saying that. Admittedly, award money has been paid, reference has been made. Can the writ court set aside the award passed by the learned LA judge?
This is not under challenge here. This is
Well,
not under challenge here.
No, what is it? But kindly see the play.
You are arguing about the consequences of the order.
No, I'm kindly see the prayer made in the writ petition at page 91. Have you also got it? Page 91. A writ of order in the nature of mandamus and or other appropriate writs or writs, order directions or direction declaring the award dated 27th October 1995. Award 27th October 1995 marched in the LA award passed by the learned civil judge.
Yes.
It becomes a degree of a civil court.
After reference under section 18, it was a decree.
A degree of the court. But a each court cannot set aside the degree of the civil court. And 12th August 96 in a case number such and such, that is the reference case. Number I have not reading. Situated in lying in Moja, Purbo-Topsia, jail number 7 within police station previously Taligan, subsequently PS Jadavpur, thereafter Tiljala, presently within PS Pragati Maidan under Astral undivided district of 21, now within district of South Africa, invalid, bad, and cannot be sustained in law. But can this order be passed by the writ court after 17 years? Can you see the prayer? B. A writ of or in the nature of mandamus, commanding the respondents to withdraw the acquisition proceedings in CS plot number such and such, situated in lying at Mauja, Purbo-Topsia within police station, previously Taliganj, subsequently PS Jadavpur, thereafter PS Tiljala, presently within Pragati Maidan under Astral undivided district of 20 Parganas, now within district of South Pargana, which were sought to be acquired under LA case number 1940, which was initiated for acquisition. But his challenge is that entire acquisition proceedings should be set aside, including march as a degree of the civil court after reference by the civil judge. Then can you see a writ or order in the nature of mandamus commanding the respondent received consent set aside the award declared on 27th October 95 in LA case number such and such of 1948. which admittedly merged with the reference
Yes.
of the LA judge. A writ in the nature of mandamus and or appropriate writs, other order directions declaring that the lease dated 30th June 1996 being annexed a deed of renewal of modification, being annexed a deed of sublease registered such and such. That is not with regard to the, I should not make any submissions because this has been done by the corporation. The state should not make any submissions with regard to the prayer deed. Prayer D, E also I cannot make any submission because this lease deed has been executed by the corporation in favor of the respondent number 5, 6, and 8. Remember, kindly see F. F. Restoration of possession. When the writ court has got any power, when kindly see writ or nature, mandamus commanding the respondents. Possession of CS plot number such and such, situated in line Bahuja, Purvat of Shia within police station Taligaj, subsequently PS Jadavpur, Tiljala presently within PS Pragati Maidan, Austral undivided 24 acres north, now district 24 acres, were sought to be acquired on the LA case number initiated by the First Land Division Collector Kolkata to the petition on payment of rental compensation from 6 December 1971. Can you see that date? 6 December 1971. Claim filed in 2017. And more than 30 years, 71 to 2017, 30 plus 17, 47 years. My lord, we exercise the jurisdiction under Article 206, restored possession after 37 years.
Yes.
My lord knows that this is called de facto doctrine. A session judge was appointed by the government in consultation with the High Court. Subsequently, appointment was challenged by one of the candidates. Then it was found that his appointment as a learned session judge was not valid, and accordingly, appointment order was cancelled.
Yes.
The question came up for consideration whether any order passed by the learned session judge can it be said to be invalid because his appointment has been set aside by the court. Just I'm giving you an example. Supreme Court should know de facto doctrine. His appointment may be declared as invalid, but if any order is passed by the learned session judge, that cannot be settled. But what my learned friend said that the learned LA collector has no power to pass an award on a particular date when the award was published. But kindly see Section 7, Act 2 of 1948, 7A was amended. That is that. Yeah, I'm thinking why. And kindly see page 134. When section 7 capital A was amended. Have Lordship got it?
Yes.
Section 3. Insertions of new section 7A. After section 7 of the Principal Act, the following section shall be inserted. Award by the collector. The collector shall make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of the notice in the official gazette under subsection 1A of section 4 to as the notice, as if such award is made within the appropriate period, the said notice shall lapse, provided in case where the said notice has been published more than 2 years before the commencement of the West Bengal Requisition Acquisition Act 1948, the award shall be made within a period of 1 year from the date of commencement of that act. Exploration. In completing the period of 3 years or 1 year as the case may be, under this section, the period when action or proceeding shall be pursuant shall be noticed is stayed by the court's order having duration shall be executed. Mala kindly see. When it was published on 8th of October 1996.
8th October 1996.
And Mala kindly see the date of publication of the award. March 1995. Page 138. You look at it. আমার কাছে দেওয়া যাবে 31st March 1995. And 12th August 1996. And this 12th August 1996, paragraph 9 of the affidavit in opposition. Kindly see paragraph 9 of our affidavit in opposition. 2 awards are there. But kindly see our affidavit on opposition.
Yes. One is 27th October and second is 12th August.
But kindly see paragraph 9 of our affidavit in opposition.
Xerox copy of your watch.
May I permit to place the paragraph 9?
Xerox copy আছে the original কোথায়
Can you see paragraph 8? Page 17 of
just
the
it.
8.
Paragraph?
Paragraph 8, middle portions.
Yes.
10th line. It is apparent clear that the award was declared after completion of the recommendation proceeding. The copies of the representation then Mala kindly see. Paragraph 9. Page 19.
What are you reading?
Para 9, page 19.
Opposition of
opposition.
Your opposition?
Yes, opposition by the state. Huh? Oh, sorry. Opposition of Prasad Rai. Sorry, that is Calcutta Mills out option. Sorry. Calcutta Mills out option.
That is respondent number 5. দেখো তো।
As engineer.
Yes.
Corporation.
3 and 4. Yes.
Corporation.
Paragraph 9.
Paragraph 9.
Yes, proceed.
It appears the petitioner under misconception have been making purported continuous without appreciating fact the compensation money as calculated towards award of acquisition property in question were duly disbursed to the person as found to be entitled. The petitioner interest including some of the petitioners has duly collected the compensation money towards acquisition of the property in question in connection with LKS number 1271 of 1948, wherever points urged by the petitioner may not be available to them to back up drop the facts case. Then Malakan see page 20. Page 20.
Yes.
Third line. The petitioner had so long slept over the right, if at all, since 30th September 1980. I do not admit that no award was declared in Elikas with the validity period of such was 95. I have purportedly sought to take advantage of the amendment of 96, saving the year 1948. And I kindly see the state affidavit. Paragraph 9 of the state's affidavit affirmed by HON'BLE Sengupta. Page 14.
Paragraph 9.
9.
Yes.
That the awards made in terms of the Honorable Court's order. One lot, you also has seen a writ petition was moved in 1993. This Honorable Court directed to complete the proceedings and to pay compensation. But if something has been done in terms of the court's order, High Court's order, can it be challenged in a subsequent writ petitions after 17 years? That action is without jurisdiction. After submitting the jurisdiction, he has got the remedy available. No, this acquisition proceeding cannot be sustained because this acquisition proceeding is not valid. Period has been, it has not been used for public purpose. 1993. Award has not been passed within the time. Kindly set aside the award. But if that issue ought to have been made available to him under section 11 of the Civil Procedure Code, constructive res judicata, expression 5, that award in terms of the High Court's order in respect of 19.90 acres being total amount of rupees 17 lakhs 54,000 such and such on 27th October 95, the draft award of the rest of the area about 66.95 acres of land was prepared as per title note, and the same was approved by the government and the Land Reforms Department on 5th August 1996. Based on the same draft award, where final award was declared on 12th August 19 and payment was made to the Special LA Judge Alipur in favor of the writ petitioner. then hence the entire exercise of acquisition proceeding was completed with a declaration under section 7A of the 1948 Act. And this has been replied in paragraph 10 of the affidavit in reply.
Yes.
Arakta koi. Arakta koi. 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 Then Kanshi paragraph 10. The petitioner thereafter filed a reference case under section 18/1894, raising objection of the amount of compensation calculated by the authorities as per award declared on 12th August 1988, mentioned that the acquisition proceedings having not been challenged attained finality on 12th August 1988. I placed before Lordship section 7 capital A of the Act of 1948.
Yes.
On the 12th August 1996, one of the cause of action, writ petition filed in, assuming for a moment, this entire proceedings from 1971 to 1996 is invalid. It was not for public purpose. Can be writ court, exercise the jurisdiction, extraordinary jurisdiction, court of equity. First, question of limitation. Second, this point was made available to the writ petitioner when the writ petition was moved before this honorable court. And in terms of the court's order, we have passed an award, made compensation. There is a reference. Then award passed by the learned LA judge is a degree of the civil court.
Decree.
If the degree of the civil judge is there, can the writ court set aside that degree? Now that's why the Supreme Court, a constitution bench judgment. But what is the period of limitation? 1964, Supreme Court, page 106. Yeah, Devan. AIR 1964, Supreme Court, page 164, Supreme Court, 1006. State of Madhya Pradesh versus Bilebhai Bhali.
Paragraph.
Yes. Yes. Paragraph 17. But according to my searching, I have not been able to search that this judgment has been overruled by any judgment. Although this I have placed before Lordship 3 judges judgment on the point of limitation revision. And but this judgment of the constitutional, can you see the number of judges? Justice Gajendra Gajkar, Vanchu, Justice Dasgupta, Justice Shah, and Justice Iyengar. Till date, this judgment has not been overruled by any other judgment. But here this case is my dear Lordship. Madhya Pradesh government issued a notification for imposition of tax on sale tax.
Okay. Imposition of tax on
certain goods.
Okay.
Then it was challenged that the state government has no power and we have paid this tax amount. This amount should be refunded.
Yes.
After that, the point was there. When the order was passed and when the refund can be made, period of limitation for me invoking the jurisdiction order to The
Yes.
Supreme Court said the period of limitation just like a civil court. But Article 58 of the Limitation Act will apply. Maximum 3 years. Well, that has been said. At this stage, we cannot lose sight of the fact the special remedy provided in Article 226. Have you also got it?
Just right.
Page
Paragraph 17.
Paragraph 17.
Yes.
If I'm wrong, I'll kindly correct it.
Proceed.
Kindly see paragraph 15 first.
Paragraph 15.
We see no reason to think that the high courts have got not the power. If a right has been infringed, whether fundamental law, the statutory right, and the agreed party comes to the court for enforcement of the right, to not be giving a complete relief if the court miserably declares the existence of the right or the fact that the existing right has been infringed. But there has been only a threat to infringe the right. An order commanding the government or other authority to not take such actions complete would be sufficient. It has been held by this court where there has been a letter threat only and the right has not been actually infringed and application of the should be lie. And the court should have necessary relief by making an order in the nature of injunction. But in 1993, this point was made available there. This entire exercise proceedings should not be done. Injunction could have been done or short for from this honorable court, they have not done. Then Malak, can you see the delay? Paragraph 17. When a right to property after amendment of 1979,
Yes.
second amendment, is not a fundamental right. At the same time, we cannot lose sight of the fact that the special remedy provided in Article 26 is not intended to supersede completely the modes of obtaining a relief by an action in the civil court or to deny defense against legitimately open in such action. It has been made clear more than once that the power to give relief under is a discretionary power. This is especially true in the case of power to issue writs in the nature of mandamus, among other several matters which the high courts have rightly take consideration. They exercise that discretion is the delay made by the aggrieved party in seeking this special remedy, and what excuse there is for that. Another is that the nature of the controversy of facts and law that may have to be decided as regards the availability of the consequential delay. That when there is cases a person comes to the court for relief under Article 226 on the allegation that he has been assessed to a tax under the void legislation and having paid it under a mistake, is entitled to get back if the court finds that the assessment was void, being under a void provisions of law and payment was made by mistake. It's still not bound to exercise discretion directing repayment. Whether repayment should be ordered in exercise of discretion truly depends on each case on its own facts and circumstances. It is not easy for its desirable to lay down or rule any universal application. It may, however, to be stated as a general rule that if there has been an unreasonable delay, the court ought not ordinarily lend its leg to a party to the extraordinary remedy or mandamus. Again, if there is no such delay, the government or statutory authority against whom the consequential relief is paid for raises a prima facie tribal issues as regards the ability of such relief on the merits of the grounds. Like limitation, the court should ordinarily refuse to issue the writ of mandamus or such payment. In both the kinds of cases, it would be sound use of the discretion to leave the party to seek the remedy by the ordinary mode of action in a civil court and to refuse the exercise in his favor in extraordinary remedy under Article 226. That means civil court's limitation maximum 3 years. And if award has been wrongly declared or not competent by the collector in 1995-6 and 2017, that's a first, kindly excuse me, Madam. First time I have pressed before Lordship the date of affirmations. 2017, the petition was filed before the Supreme Court.
Yes.
For exercising the extraordinary
civil jurisdiction.
Madam, today, if this writ petition is allowed, acquisition proceeding is set aside. Assuming for a moment whatever said by Mr. Bera is accepted. What is the effect of it? Then my lord shall have to set aside the award passed by the learned LA judge. And Madam, Science City has to be abolished, which has been for public purpose. So for other property, I am not making any submission because it is made by the corporation. Assuming for a moment that LA collector was not empowered to declare the award. I have placed made some
it was not
de facto doctrine.
De facto doctrine. Yes.
His action cannot be invalid. His appointment may be illegal, but his actions cannot be invalid. I have given an example. This was the case before the Supreme Court. And my Lord Justice Saraswati Mukherjee also decided that. De facto doctrine is that if such person's appointment is invalid, but his actions cannot be declared invalid. Because when award was passed, award culminated in the award passed by the learned LA judge. And that becomes a degree of the civil court. And so for the other certification that transport deed, But I do not know whether, I will not make any assumption, whether the deed court will exercise that jurisdiction, setting aside the transfer deed, registered deed in favor of the third party. Or state was not party. If he has got anybody, he can file a civil suit. Just Supreme Court said so. Assuming for a moment this award was invalid, his period of limitation is 3 years from the final award, 1996 or 98, kindly say, maximum time. 99, 2000 and 2001, 2017. Because third party right has been accrued. And my land fund has placed reliance upon 2011-12 SSC page 375. এই ঠিক তো বেড়া তুই দেখেছিস গেটার নয়ডা ইন্ডাস্ট্রিয়াল last year the kindly see I think 2011-12 SSC page 375
পুরো সেটটা
12 তুই দেখেছিস তো আমি সেটাই ডিস্টিংগুইশ করছি 2011-12 SSC page 375
2011-12 SCC 375
হ্যাঁ
Greater Noida Industrial Development Authority.
This is the last case cited by Mr. Bera.
Paragraph 35 and 39 was read.
But kindly see what is the facts. In Buddhanagar, it's called Greater Noida, there was a land division proceedings. And they have exercised the emergency power under the Land Division Act. In that prospect, this was observation. Kindly see. Observation. Paragraph 27, 28. Paragraph 29 also. There is a violation of natural justice, emergency power about exercise for a particular purpose. But here we exercise any emergency power? No.
No.
71, we have issued a notice. 1981, section 4.1 notice was issued.
No, it was argued by the petitioner that in the case of Greater Noida,
oh yes,
the instances for change of purpose.
Change of purpose.
Change of purpose. They have acquired for the purpose of development of industrial built, planned industrial development, but they have transposed it to the some persons who have developed, changed the plan, and multi-storied complexes were prepared. That's why the High Court has caused the acquisition.
But section 17.1 was there.
Yes, emergency power.
Emergency power.
Emergency was invoked.
But any small fact or variation of the facts, the ratio in India may not be better applicable. That's a I'm
Okay.
not. But so far as the proposition of law laid down by the Supreme Court, I am not disputing that. But in my submission that on a particular facts, because
emergency provision was invoked.
Emergency power was exercised, and for agricultural land was taken for development of dwelling houses, depriving the citizens without giving natural opportunity. I mean, that was decided in paragraph 28. 29. We shall now deal with the argument of the Landed Council for the builders. The impending order has visited due to violation of the rules of natural justice because the High Court disposed of the depreciation without ensuring the implement of all the persons whom the land was allotted authority by giving bids and giving the. There is no substance in the compliance of the builders. The petition had a question the acquisition of land mainly on the arbitrary exercise of power and non-application of mind by the state government and denial of opportunity of hearing to the landowners. But here, is paragraph 30, can you see? Yes. Entire case is in paragraph 30. Huh? The High Court entertained the writ petition and directed the parties to maintain status quo. If Devendra Kumar, the stay order was granted on 7th October 2010 in the presence of the council representing the writ petition of the state of PP and the authority. Thereafter, similar orders was passed in the writ petition. It is neither been placed before this court nor Sri Mukul Rohatgi, learned senior counsel, argued that the functionaries and officers of the authority were not aware of the pending litigation and the orders of the status quo passed by the High Court. Therefore, the exercise undertaken by the authority to devise schemes of allotment of land to large group of housing builders, residence plots in the first week of January 2010 and thereafter allot plots measure of 60,000 to 40,000 square yield to the builders by inviting bids from those who offer a reserve price of 60 crores to 400 crores was nothing but a present attempt to overreach the process of the court. But can you see that? There is an order of status quo. The beneficiary of such blatant violation of the orders of status quo passed by the High Court cannot make a complaint and they were not given the opportunity of hearing. This is the fact. Although the senior counsel appearing for the that the land allotted to his client was not covered by the order of the status quo, I'm not. Paragraph 32. It is difficult, if not impossible, to believe that the builders were not aware of the pending litigation, despite the fact they had successfully manipulated the change of land use and modification of the development plan in active connivance with the functionaries of the authority and the state government. The note dated 20th October 2009, recorded by the Industrial Development shows that the officers concerned were known the pending writ petitions with a view to make infructuous stay order, which was likely to be passed by the High Court. The process of issuing notification under section 6.1, read with section 17, was hastened. This shows that the designed attempt was made by the functionary officers of the state government authority who had convinced with the builders to frustrate the right of the tenure holders and other interested persons to seek remedy before an appropriate judicial forum against unlawful deprivation of their legal right and constitutional right. For the reasons above, we hold that reverse.
So, for the act of imposition of emergency power is under challenge.
A challenge. And there is a status quo order by the High Court. And in violation of the order, entire proceeding was completed and or completed. But when there is an order of interim order passed by any court, whether civil court or whether writ court or court, that should be respected. In our case, and in 1993 you could have challenged it. Kindly do not proceed with the land division proceeding. Kindly set aside the land division proceedings. And the writ procedure. Whether in a writ proceedings, res judicata principle will be applicable or not. That came up for consideration before the Calcutta High Court to Supreme Court. 2014-11 SSC, page 744. 2014-11 SSC 744. Shivchandra More versus Lieutenant Governor. Paragraph 21 to 23. May I permit to press?
Yes.
we may briefly refer to, but because this is from Calcutta High Court, we may briefly refer to some of the decisions which elaborate the principles and extend their application to the proceeding before a read court. But before we go to say that is right, namely the doctrine of res judicata being one of the fundamental and unsettled rules of jurisprudence. The doctrine is found in all legal systems of civilized society in the world. It is founded on the twofold logic, namely that there must be a finality of adjudication by the competent court. No man should be vexed twice for the same cause. That these two principles attack the doctrine of res judicata into interpret this decision that may erroneous on a question of law. The doctrine is applied after if the decision exercised by the superior courts in country is settled by the constitution bench decision in case of such and such. Therefore, there can be no doubt that general principles of res judicata applies to the writ petition filed under Article 32 or Article 226. It is necessary to emphasize that the applications of doctrine of res judicata to the petitions filed under article does not or in any way impair or affect the content of fundamental rights guaranteed to the citizens of India. It only seeks to regulate the nature of which such rights could be successfully asserted and indicated in courts of law. These principles of constructive res judicata, which are also part of the very same doctrine, have been held to be applicable to the writ proceedings. In another constitution bench decisions in Devilal Moti versus that is reported in 65 Supreme Court 1150. It may be concerned in our Mr. Trivedi that the rule of constructive res judicata which was pleaded against him in the present appeal is a sense of someone technical or artificial rule prescribed by the Code of Civil Procedure. This rule postulates that if he could have taken a by party in a proceeding between him and his opponent, he would not be permitted to plead against the same party in a subsequent proceeding which is based on the same issue, cause of action. But the cause of action is acquisition of the land. Yes, by the collector, by the government. Collector by the government, right, following the law. That was available to him in 1988. But basically, it is the view has been found on the same consideration of the public policy because it is doctrine of constructive res judicata is not applied to the writ proceeding. It would be open to the party to take one proceedings another new grounds every time that plainly is inconsistent with the consideration of public policy to which we have just referred. Reference to be made to the constitutional decision in direct recruit class engineering association versus state of Maharashtra, that is 1990 volume 2 SSC 715, where this court once again reiterated the principles of constructive res judicata apply not only what is actually adjudicated or determined in a case, but whatever other matter which a parties might ought to have been litigated for which indulged or essentially connected with the subject matter of litigation. An adjudication is conclusive and final not only as to the actual matter determined, but also every other matter which the parties might ought to have litigated and have decided as identical to or essentially connected with the subject matter of litigation, and every matter coming into the legitimate purview of the original action, both in respect of matters of claim and defense. Thus, the principles of constructive res judicata underlying expression Roman 4 of section 11 of Civil Procedure Code was applied to writ case. We accordingly hold that writ case is fit to be dismissed on the ground of res judicata. In this light of it is in the light of the above authoritative decisions of the court no longer open to the appellant to conduct the principles of res judicata would not divert them from raising question which was observed earlier. We go to High Court. What is that discussion? But then, in 1993, this issue was made available to him. This issue, cause of action was there. There's 71 notification issued under section 3.1, 1981 4.1 notification issued, and this proceeding should not be allowed to continue. This should be paused. Rather, they could have got order, kindly complete the proceedings and pay the amount. In compliance of the court's order, we have completed the proceedings and published an award, paid the money, and terminated in a land acquisition proceeding. And my learned friend has placed judgment of Justice Bhattacharya. (2011) Volume 3 CHL 5333, State of West Bengal versus Sobita Mondal. No, he has been placed by Mr. Devan Bada. 2011, volume 3, Calcutta High Court notes, page 555, full bench.
That is 3 judges bench, I think.
3 judges bench. And 7A has been quoted in page 96 amendment has been quoted. 7A has been quoted.
Yes. Revival of LA proceeding.
Ultimate analysis is paragraph 23. With great respect, the said division bench were unable to accept the said interpretation of amendment of 1996. Although the said act was published in Calcutta Gazette on 8th of October 96, division bench totally overlooked the subsection 2 of section 1. That very amending act, it was specifically provided the said amending act should be deemed to have been come into force 1st April 1994. Moreover, after proviso of section 7A, the date on 31st March 94 was specially mentioned after the word that act, which totally escaped the notice of the division bench as would appear from the quotation of the said proviso. Thus, there is no scope for interpreting the words that act as the Act of 96, only the date of commencement of West Bengal Requisition Acquisition Amendment Act 94, specially mentioned at the end of the proviso, where the intention of the legislators was clear. There is no scope for ignoring the proceedings in the respect of notice given prior to 1st March 92. Prior to 1st March 92 stood last if the award was not published within 1 year from 1st March 94. We thus hold that the under deferring bench was the court rightly refused to follow a view taken. In our view, the appropriate findings should dismiss the first 3 appeals filed by the state and affirm the order passed by the lingering judge. So far, the fourth matter, such and such, it appears that the notice was issued prior to that, the same should be treated to be a lapse, and the state shall be fresh notice under section 9(3) of the said proceed accordingly if it appears to be by the following the principles laid down in this case. The notice under subsection 1A of section 4 has been lapsed. Compensation has been calculated on the basis of the valuation on that date. At that date, fresh awards would have been. Kindly see, their lordships decided on the issue amendment of 1996 and 1997 and Act 2 of 1940, and reference was made. But in our case, LA judge reference was made. There is no discussion about LA judge reference.
Now, in the case of Sabida Mandal, there is no reference.
There is no such case.
No such reference under section 18.
If there is no case, was not there. If there is no such, at least factual aspect was not. Okay. This fact was not there. But I'm saying that whatever the proposition has been law said by a larger bench, binding upon us. But the super factual aspect of the act is concerned, that award published by the LA judge was challenged before the reference court, and reference court passed an award. If reference court passed an award, I wonder how this principle could be applied. I bet God. May I maybe give you some more time, any other day?
Okay. Today you are not concluding. Very good.
Next hearing is continuing for the state. Once they finish, then the corporation will argue. Then our turn will come as private.
Yes, let them finish.
I will not take
I'm
much more than
one request we are making to the court.
You are for the?
I'm for respondent number 5.
Respondent 5.
What are the private respondents?
Private respondent. So now respondent state, and thereafter
Corporation.
MC.
Then our turn will come
Yes.
one by one. There are many questions. Now only one request I'm making. My learned senior friend for the petition has had submitted 17 judgments, cited 17 judgments, and made argument for about 5 days. But the only request, but if he can summarize that and file a written note.
Summarize?
A written note in court, so that we can, when we sit with our seniors, but that
That is not required now. Let it complete first.
Because we have to sit, we have to now sit.
No, it is for the assistant of the court, not for the assistant of any party.
Only thing
You
is
cannot sit like
we
that.
have to sit with our seniors and.
No, no, no. No, you just take note. You have to learn.
List of dates are prepared in the next date.
Yes, you can place it, no issue. When next Thursday I have fixed one matter. Which matter? এটা ফিক্স করেছি 1 নম্বরটা ফিক্স করেছি দেখি কোনটা মাসের দিন দাও এটা করে দাও এটা ওইটা করেছি আর কোনটা কোনটা নেক্সট থার্সডে
কত তারিখ হলো 14 at 2 p.m.
argument on behalf of the state continue. Let the matter appear in the list on 14th of August 2025 at 2 p.m. as a second matter. I have fixed only one matter. Thereafter, this matter.
No, kindly permit me to prepare a short list of dates.
Yes, you can prepare and place it. No issue.
প্রচুর কারেকশন
ওরা চলুক ওদের মতো করে এটা রাখো এটা আলাদা করে রাখো হ্যাঁ এটা স্টেটের দেখি না 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 একটু নিয়েছি এটা পিছানা হ্যাঁ বাকি সব পিছানার উপরে এই তিনটে স্টেটের আলাদা করে রাখো এই বইটা মনে হয় ওদের নিয়ে নাও বই ওকে থ্যাংক ইউ
দারুণ দারুণ